kindly list the matter for tomorrow or day after, Lordship. He will list today.
No, you see today. Ask any junior to be there, or you be there.
Lordship.
May I please, Your Lordship? I beg to mention for listing one writ petition in admission column, Lordship. Motion column, Lordship. Tomorrow, Lordship.
May I please, Your Lordship? With regard to the item number 2, my lord, item number 2, my lord, I have two cases of 1 and 3, my lord, in court number 5. My lord, some time may be accommodated.
May I please, Your Lordship? I beg to mention for a listing of a writ petition for motion column tomorrow, Lordship.
May it please, Your Lordships. Similar prayer, Lords. This is a stay vacating application, Lordships. Matter was stay vacating applications, Lordship, in respect of a tender matter, Lordships. Letter of acceptance has already been issued in my favor, Lordships. Now there is a stay operating, Lordships. In view of the letter of acceptance which has been issued, we were required to put the machineries at the site, Lordships. We have
You
already
filed a stay vacating.
we have already filed, Lordships.
When?
Lordship, that was on 22/7. Thereafter, this matter was last listed on 27th of July, Lordships. Lordship, but the Lordships expressed their inability to take the matter. Lordship, tomorrow or day after, Lordships. As my Lord.
Friday.
Friday, Lordships. I'm sorry.
In the stay vacating column. Don't put it in admission. Put it in stay vacating column.
Stay waiting, Lordships. I'm making a
Because otherwise, if you put it in admission or it comes in
No,
order.
Lordships, I have made a categorical statement. Orders,
vacating.
brackets, stay vacating, Lordships. I'm sorry.
May I be, Lordship? I
Yes.
beg to mention item number 10 and 11, Lordship. So the 11 and 12, Lordship. Lordship, in this case, Lordship, last night I was in hospital in Prohibitions hospital with my son, Lordship.
What?
Last night, Lordship, I was in hospital, Lordship. Morning, Lordship, I have come, Lordship. And kindly, Lordship, this may be a matter may be taken up on Monday, Lordship. Kindly, Lordship.
What is the matter about?
This is a contractual tender matter, Lordship.
Stay is there.
That just an observation is there subject to the outcome of it. On Monday, kindly, Lordship. On Monday.
Is urgency?
Stay is operating, my lord. Stay is operating. It was cancelled when, my lord, subsequently, my lord, there was a stay. This honorable court modified it to the extent that we will proceed. And, my lord, whatever is the outcome will be subject to, my lord, the result of the.
There is no urgency.
Let it be on Monday.
On Monday, Lordship.
We have it in the month of November.
Kindly, Lordship, Monday, Lordship.
No, sorry. Cannot be a theory here. We'll have it in the month of November. No urgency. What is the period of the work?
Lordship, 9 months, Lordship. Lordship, kindly, my
How
Lordship,
many
for
months have gone?
It was issued in August, my lord. In between, there was a
Lordship,
stay
in
order
this case, Lordship, the letter of acceptance was issued on favor of the petitioner. Subsequently, they have, Lordship, without assigning any reason, Lordship, they have, Lordship, when the petitioner approached this court, Lordship, they, Lordship, came with instruction that, Lordship, they have cancelled their, Lordship, decided not to grant the work order to the petitioner. Thereafter, Lordship, what happened, Lordship, they have now, there is the direction of this honorable court, Lordship, that the decision is to be communicated.
Isn't
to
that the Empire Singlu matter?
My lord.
The Empire, there's another case which has been done. If I not remember, along with Rana Construction, I have disposed of. Is this the case?
No, Lordship. Kindly, Lordship, on Monday, Lordship.
No.
Lordship, because of my personal leave, I was in hospital, Lordship, with my son, Lordship, yesterday night, Lordship.
But it
Kindly.
cannot be understood, but Monday is a different day. It cannot.
Then Tuesday, Lordship.
Okay, Monday, I don't think I will be sitting out there on Monday.
Obliged.
The request of the learned counsel for the petitioner, matter stands adjourned to be listed again on Monday.
Obliged. Lordship, it may be passed over for the time being.
Why?
Lordship, my senior is in legs in another court, so after some time.
Lordship, matter may be taken after some time. My senior is court number 8, Lordship.
What is the matter about? Very deep. What is the matter about?
Lordship, I am not going through the brief, Lordship.
As the counsel for the petitioner is not present, let the matter be listed after 2 weeks. Next. 2 weeks on 14th of September. Let the matter be listed again on 14th of September. None appears on behalf of the petitioners on call. List the matter on 18th of September. Same order. None appears on behalf of the petitioner and counsel as the respondent. Matter stands withdrawn to be listed on 25th of September.
My lord, by order dated 13/5, your lordship has directed the respondent to file additional affidavit in respect of my lord security deposit. But they did not file, my lord.
Lordship,
Although they have, on the last occasion, they have filed one instruction, my lord.
Yes,
Lordship, as per instruction, Lordship, payment has already been made.
No,
Lordship,
I
on
have
the
not
last
received.
occasion, matter was not, on the last occasion, matter was not reached. আপনার সব কপি বেশি দিন না last এটা দিয়ে। Yes.
this is for 22 lakhs 80. How much it is? 28 lakhs and 2 lakhs.
And 2 lakhs, 28 lakhs 800 plus 2 lakhs, total 30 lakhs 800 was the pending amount, which was released on 2/7/2026.
Now, this is okay, but what about the security deposit?
Lordship,
The petition was filed for 3 crores 52 lakhs,
yes, Lordship.
which included 2 crores 40 lakhs as outstanding dues and remaining amount to security. You have admitted 2 crore 40 lakhs.
Yes, Lordship.
How much you have paid? 20 to 30 lakhs.
30, we have received, my lord.
So where have you paid that amount? And what about the security deposit, which I have asked you?
No, Lordship, the calculation is, Lordship, total amount has been paid, three installment, Lordship. In 2 installment, Lordship, 55 lakhs 38,770 on 25/3/2019, it was released. And thereafter 18 lakhs was released on 8/9/2020, and thereafter 30 lakhs.
Understood. But here in
That-
your affidavit, you have duly admitted.
Yes, Lordship.
In the affidavit, kindly see in your affidavit, you admit to the amount of rupees 2 crores 40 lakhs at paragraph number 6.
Yes, Lordship.
If that is so, why are you only paying this amount of this paltry amount of this around 85 lakhs? And apart from that, there is no mention as regards the security.
Lordship, can I get 10 minutes time, Lordship? I have to, this calculation I have to check, Lordship. 10 minutes time, Lordship.
Now, why haven't you filed the affidavit?
Lordship, as per information, Lordship, as the.
No. First of all, haven't you mentioned at paragraph number 6 of your
Yes, Lordship.
affidavit? So you are not prepared with your matter?
Lordship, kindly, Lordship, 10 minutes time, Lordship.
It's a very sorry state of
Lordship,
affairs.
kindly, Lordship.
We'll put it out there. It's a very sorry state of affairs that in spite of a specific direction being issued by this court on 13/5/2026, the respondent number 2 to 6 have not filed the additional affidavit mentioning about the security deposit, giving details pertaining to the security deposit and the performance security. Further to that, the learned counsel who appears on behalf of the BTC seems to be unaware of the contents of the affidavit, wherein it is specifically filed by the respondent number 2 to 6, wherein it is categorical admission. There is a categorical admission that the petitioner is entitled to an amount of rupees 2,40,35,401. This aspect is apparent from the fact that the learned counsel have placed before this court that the amount have been already disbursed to the petitioner. And on inquiry, it is found that the amount which have been disbursed since 2019 till date is around 85 lakhs. Full stop. This court expects the BTC to pull up their socks. This court expects a better assistance from the standing counsel of the BTC. This matter again on 7th of September 2026. Full stop. In the meantime, the respondents 2 to 6 shall bring on record an affidavit as to how much amount has been paid out of the total entitlement of the petitioner, failing which this court shall require the presence of the respective officials of the BTC, more particularly who is responsible?
Executive engineer, my lord, respondent.
Mr. Counsel, grow up. In this court, don't say about these executive engineers or these engineers.
To my lord, secretary come nodal officer, 5th APV.
The respondent of the secretary come nodal officer. BTC as well as the additional chief engineer come director public works department thereafter. The affidavit be filed on or before 28th of August 2026.
My name will be shown.
What? What do you want? You have not appeared.
Sorry, my lord.
We put it out there. At the end of the period, Mr. NNB Chaudhary has appeared and seeks his name to be inserted. It is unbecoming of a senior advocate to make such a request. Should we put it? Cut it out. Don't come up with this.
May it please your Lordship, the petitioner is a coal depot owner from Margareta. On 15/7/2024, a notice was received by the mother of the leaseholder that certain documents are required to be produced. Thereafter, my lord, I have produced all those documents before the authorities, but then they went and seized my entire coal depot, and that was put to auction. After which this honorable court was gracious enough to grant an interim stay on that auction, and my 270 tons of coal was not to be touched. The directions were given. My lord, after that, there are 2 points on which the entire seizure stands, my lord, today.
Who has done this?
My lord, this has been done by the district commissioner, my lord.
Huh?
District commissioner authorities, my lord.
Deputy Commissioner?
Yes, my lord. Respondent number 3, co-district commissioner, Margareta.
What has he done?
And he has seized my entire coal, my lord.
Why?
And then he has put it for auction. That is the issue, my lord. I have not been provided a seizure list. nor the report of this seizure has been made to the magistrate, jurisdictional magistrate. Now, on this two stands, my lord, the entire seizure of this coal is vitiated.
So you were taking the coal from one place to the other after auction?
No, my lord,
Then?
nothing such. So what has happened is I have purchased certain coal. I have kept it in my leased property for which I have taken their lease deeds also. Now, when this was in my possession and it was there, they have sent me a notice. That is the first notice, not in my name, but in the name of the mother of the landowner. Thereafter, I came to the knowledge that certain notice has come. I have provided all the documents. Those are also annexed here. Thereafter, my entire coal was seized and put for auction, and that I came to know through the e-auction notice. So I hurriedly came before this court, and this court was pleased to grant me
Who seized it?
my lord, MSTC Limited. That is MSTC Limited, Ministry of Steel,
Ministry of
and Ministry of Steel, my lord, Government of India.
MSTC.
Yes.
You don't know the meaning of MSTC?
No, my lord, it is the Ministry of Steel who put us to
Absolutely not the ministry. MSTC is the auctioneer.
auctioneer, my lord.
Then they have put it to auction.
Yes.
How do you know that that is the coal?
My lord, that is what in page 56, my lord, will find, annexure 9. There are certain lots, and out of the lot on page 57, lot number 4.
Understood. The coal you have taken on auction,
Yes, sir.
you have put it in your godown.
Not auction, my lord. I purchased it. The bills are there.
Whatever may be, you have purchased it. You have put it in your godown. Now, after putting it on the godown, they seized it.
Yes.
Okay. Now, after seizure, where is the confiscation proceedings? How can you put it to auction? First of all, or whether it is at all that coal, because you don't know, the coal is always black. We only know that. How do you identify that it belongs to you?
My lord, for a moment, if I may, the coal is still lying in the godown. They have not taken it and moved it to another place. But what they have done is for the entire district of Bordeaux, that is the Margaret area, they have confiscated certain amount of coal from numbers of depots. And my lord, my certain belief is that my auction, that 270 tons is also between that metric
How do
ton.
you know?
My lord, I have been, my lord, this is
You
the
cannot know that.
but my lord, I've been seized. Those my
If there is a seizure, there is another proceedings for removing. But whether there has been a confiscation,
Yes, my lord. In fact, my lord, we have filed affidavit, my lord.
what do you
Response
say?
number 4, my lord.
What do you say?
Page 71, my lord.
Huh?
Page,
Para-
page 71, my lord. Of the affidavit filed by response number 4, my lord.
Paragraph.
Paragraph 6, my lord.
So it is under the investigation, not confiscated. Unless it is not confiscated, how can they put to sale?
So that has been done here. And also, Lordship, the Caesar list has never been provided to me.
They have not provided the seizure list.
And also, this order is not there, my lord.
My
It's not this order that
Where
they
is the
have taken.
seizure list? Whenever you mention about a particular document, isn't it required for filing the affidavit along with that document? What is this type of
They have
filing the affidavits out there? I think you need to, both all of you should be given this particular judgment and keep it with you, all the government councils.
My lord, the ITC judgment. The ITC judgments which speak.
What?
The ITC judgments, my lord, I have brought one that speaks about the confiscation if there is not providing of Caesar list and not proper manner in which it has not been.
That is a different thing. My question is whether if they have seized, there will be obviously a seizure list. But
Not
before
been-
that,
I have not been accorded.
one need to also let the councils for the respondents know how to file an affidavit. This is the basic fundamentals this court needs to teach these respondent counsels. মোৰ ৰঙা কিতাপখন দিয়কচোন। এই ইণ্টাৰনেটটো বেয়া আছে, ক'ত গ'ল? ইমান ইণ্টাৰনেট বেয়া। জাজমেণ্টটো ওলাব দিয়ক এইখনত। ওলাই এইখনত স্ক্ৰিনিং সেই তাত কৰিব দিয়ক। SCC online 88 1988 4 SCC 534 তো তাত খোলক, খুলি পেলাই এইখন স্ক্ৰীনত ওলাই দিয়ক। অনলাইন নহয় 1988 4 SCC 534 এখন ওলাই পেলাই ইয়াত করলাম না ইন্টারনেট দেয়া So you have been asking for a stay or getting a stay where there is no confiscation.
My Lord,
What type of stay you have got?
Lordship, the stay that I've got was that this entire there was a seizure for the entire town there. 720 metric tons.
Understood.
I
but
understand
my
my Lord's
question
query
is,
also.
how do you identify this coal with your coal?
Lordship, first of all, their affidavit also states that the confiscation has happened and they have put it for.
They have only directed for investigation.
Yes.
They have not confiscated till now.
But my Lord, the auction that they have put for and
Understood. But how do you identify that is your coal?
my Lord, that is
How?
my Lord,
Somebody informed you over the telephone.
my Lord, the entire towns that moment at which this happened and the entire town's coal that was put for auction. That is how my Lord.
Understood.
also
But
come to
the
know.
fact remains that your coal has been seized.
Yes, ma'am. I have not been accorded a season list.
It's okay. You have provided the Caesar list.
Yes, my lord, I have to take instruction that, my lord, whether that is provided or not, my lord. And I am allowed to file an additional affidavit being on all those Caesar documents, my lord.
File. Hey, Kumbajan computer manu amati video. You can do that, not others. Ask that court officer, whoever gives these court masters out there, ask him to give a better person who can do this. My court works in a particular manner. Ask that particular officer, whoever it is.
Lordship, if I may read the para 6 that he was reiterating, the lower part of it says that I'll read the entire para 6 of page 71. That with regard to the statements made in para 6 of the writ petition, the appellant states that the Honorable Court of Subdivisional Judicial Magistrate has passed an order.
Para 6, where do you get the honorable court?
The second line, page 71.
Para 6.
Yes.
Of
the additional or the affidavit in opposition that they have filed.
where is that honorable
Filed by
court?
respondent number 4, my lord.
4.
Of the court district commissioner?
Yes.
Of the district commissioner? I'm reading the respond number 2.
No, no.
Forget about the respond number 4. We are concerned with respond number 2.
My lord, just one line if I may point it out.
Para?
Para
Para
6,
6.
page 71.
Yes.
My lord, if lordship be with me on accordingly, respondent number 4 initiated an e-auction through the respondent number 6 MSTC, which in turn has issued an e-auction notice by so-and-so Director of Geology and Mining, as because the coal is perishable item, a pollutant and vulnerable to theft. The auction process is now kept in abeyance, following the direction of the Honorable Party. So, my lord, there is
What type of action you have taken? Once you seize, isn't it required for you to confiscate?
Yes, my lord. Because since it is a perishable,
Goodness. Under what authority you are doing it? You seem to be, your co-district commissioner seems to be the god out there in Margareta, because I think it is the furthest point of Assam, and then therefore they can do anything. It seems to be. This is done by the director of,
This is a joint
Geology.
director of Geology and Mining.
how? Without the confiscation being carried out. You have not given a Caesar list also.
yes, my lord.
And when was this done?
My lord, the e-auction notice, that it was
When was it done? Your Caesar was carried out?
24, my lord, in the year 24, July month.
Hello. You make out or your loss will check it out from his salary of this co-district commissioner who has done it.
Because, my lord, if
What is the name? Get the name of that officer. We do it from them. As well as the DC, he is also a hand in glove. This is a racket. It seems to be a racket on the part of this district commissioner and the co-district commissioner who have done this. How can there is some law or not? Or is it that it is so far off from Gauhati, so there is no law?
Yes, my lord.
I think it is that is the reason why the government is thinking about, because of district commissioners like you, the government is thinking of having a second capital out there to take control of these officers.
As per this affidavit, my lord, Assam mine.
Mr. B. Gogoi, what type of action is this being done? I would have understood, okay, Caesar, but where is the confiscation? Without the confiscation, how can there be a question of the property becoming yours?
My lord.
The coal is still lying in his godown.
Lordship.
So there is no place, there is no problem about that, that it has something to do with that these persons concerned are, that it will rot out for putting it to sale. How is it this being done? The respondent number 2 at paragraph number 6 of the affidavit says something else.
Lordship.
He says that it is still under investigation. Whereas the respondent number 4 states at paragraph number 6 that they have appealed to the court and the court had passed an order for putting it to e-auction. Where is the order and why orders are not being put? Have you able to get that? No. The saddest part of this, the High Court is also, yes, why have you given me people who do not know anything a head on tail about computers? Whatever may be. But they should know how to manage the computer, how to open up the SCC online. Get me somebody else who is better. Not this way. If you don't have, then ask the Chief Justice not to, for this court should not sit. You are not in a position to provide me efficient. I think we need to, the loss which is being felt by the petitioner, you have to pay from your pocket. And are your government advocates not aware about a very specific proposition of law? The judgment is 1988 4 SCC page 534. Write it down, everybody of the government advocates. They think that whatever they feel like, they can do.
Page 9534.
They are not incapable. Read paragraph 13 for your comrades to also know what is the law, how writ petitions are pleaded. Read it.
Pardon, my lord. As has been already noticed, the point is the profiteering by the state was fielded in the writ petition before the High Court as an abstract point of law. There was no reference to any material in support thereof, nor was the point argued at the hearing of the writ petition. Before us also, no particulars and no fact have been given by the special writ petitioners or in writ petition or in any affidavit. But the point has been sought to be substantiated at the time of hearing by referring a certain facts stated in the said application by SSIDC. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by fact,
Paragraph
party-
13 too, Lux. Paragraph 13.
the party raising the point, if he is the writ petitioner, must plead or prove such fact by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the fact are not pleaded or the evidence in support of such fact is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point. In this context, it will not be out of place to point out that in this regard, there is a distinction between a pleading under the Code of Civil Procedure and a writ petition or a counter affidavit. While in a pleading, that is a plain or a written statement, the fact and not evidence are required to be pleaded. In a petition or in the counter affidavit, not only the fact but also the evidence in proof of such fact have to be pleaded and annexed to it. So the point that has been raised before us by the appellant is not entertainable.
So therefore, we will hold it in view of not enclosing those documents, that these documents are not there. And accordingly, you are responsible for what you have done to the petitioner. Let's pass the judgment on the basis of that. And let the Co-District Commissioner and alia pay damages to the petitioner for the loss suffered and hand over immediately to him. These are fundamental laws of pleadings in a writ petition. Get the name of this Co-District Commissioner who have done it along with the Director of Geology. We'll take action against the both of them. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Stop. Mr. M. Sethi appears on behalf of the respondent numbers 1 to 5. Not required. You cannot, because of the fact this is the law. Once one of your officials faces trouble on account of the failure on the part of the advocate, then only they will learn. It is absolutely whoever has filed this affidavit should know the basic idea that you cannot file. Who is this filer? Some additional senior government advocate who doesn't know hide and tail. His name is also not disclosed. He doesn't know how to plead in a writ petition, how a counter affidavit is to be filed. Whose signature is this? And the best part is, he puts the notice to the senior advocate. And who has filed the other one? Yes, you. You don't know.
Yes, my lord, at that point, my lord,
You didn't learn the law.
at that time, my lord, documents were not provided to us, my lord.
So therefore, can there be a pleadings in a writ petition or in a counter affidavit without that document? A seizure list is here. There's a specific statement of the petitioner to that effect that the seizure list has not been provided. You say that we have seized it. You say that you have approached the court Did the court pass an order? Is there a statement at paragraph number 6 that the court had passed an order? No. If the court had passed an order, it's a different aspect of the matter. And how could the court pass an order to that effect? And you have put it to auction. And this is the everyday business out here for the government advocates. They have been doing it. I think we should paste this judgment out there, paragraph 13 in headlines out there. এই তাতে এখন গুছাই দি paragraph 13 to ভৰাই দিব. So that the government advocates know how to plead a counter affidavit. লেখক কি লিখিলো? So and so the learned counsel appearing on behalf of the petitioner, Mr. M. Setia, who appears on behalf of the respondent numbers 1 to 5. None. You have not filed your affidavit. Why? Have for respondent numbers 1 to 5. Appears for respondent number 1 and he appears for respondent number 2 to 5. None appears on behalf of the respondent number 6 on call. The present petition has been filed by the petitioner, challenging the actions on the part of the respondent number 3 and 4, the respondents challenging the actions of the respondent number 2, 3, 4, and 5 in seizing the coal belonging to the petitioners without in complete violation to the provisions of law. And thereupon, without carrying out any confiscation proceedings, put the said coal for sale by way of auction through the respondent number 6. This court duly takes note of the affidavit which have been filed by the respondent number 2 on 12th of March 2024, wherein it is categorically mentioned that from the petitioner's premises, the coal was seized and the premises of the petitioner was kept under seal. It is further stated in the said affidavit that a seizure list was prepared and the director of geology and mining, it was further category mentioned that the Directorate of Geology and Mining had prepared a seizure list and proceeded with further investigation to determine the legality of the coal. However, the said seizure list had not been placed on record. Contemporaneously, it is further seen that on 13th of March 2026, the respondent number 4 also files an affidavit wherein it is mentioned that the coal which was seized from the petitioner was put to sale by auction and to keep the money earned from the sale in the government treasury, keeping records and samples. There is no mention in the affidavit which have been filed that there was any confiscation proceedings or a finality has been attained in respect to the investigations so carried out by the respondent number 4. In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Bharat Singh versus so-and-so, reported in 1988, 4 SCC, page 543, and more particularly at paragraph number 13, wherein the Supreme Court had categorically observed as to how pleadings should be in a writ petition as well as in the counter affidavit. Full stop. Paragraph number 13 being relevant is reproduced here in under. From a perusal of the affidavit which have been filed by the respondent number 2 as well as the respondent number 4, no documents have been enclosed to show that there was that a seizure list was prepared, and thereupon further investigation was carried out, and on the basis of such report, the proceedings was initiated before the subdivisional judicial magistrate. Even the order of the subdivisional judicial magistrate have not been placed on record. First, taking into account the proposition of law as settled by the Supreme Court in the case of Bharat Singh Supra, the stand which have been taken, the averments made by the respondents number 2 and 4 in their respective affidavits, under no circumstances can be taken as a stand bereft of the documents which should have been enclosed. Next, this is a case wherein the petitioners this is a case where the petitioner claims that his rights under Article 300A of the Constitution have been taken away, have been violated by the respondent authorities. It was incumbent upon the respondent authorities to come up by filing a proper affidavit, enclosing the documents. There's a complete failure on the part of the respondent authorities to do so, as have been noticed herein above. This court also takes note of that on account of the violation committed to the violation of the rights committed upon the petitioner, a case of statutory tort, a case of a constitutional tort arises. Who are the officials who were responsible for carrying out such action? Under such circumstances, this court directs Mr. M. Setia, who represents the respondent number 2 to 5, to provide the names of the officials, more particularly the respondent number 3, as well as the respondent number 4, who were the officials at that relevant point of time, so that they can be impleaded in person in the present proceedings, and thereupon pass appropriate directions. This court further observes that, taking into account that the respondent authorities have seized, have taken over the call of the petitioner without following the mandate of law, the interim order which was passed has to be made is required to be continued till the disposal of the writ petition. First, the records pertaining to the seizing of the coal, as well as the records pertaining to the investigations so carried out, as have been mentioned by the respondent number 2 and 4 in their affidavits, be placed on record, placed before this court on the next date. This matter again on 24th of September 2026, The interim order passed earlier shall continue till the disposal of the writ petition.
In item number 8. In earlier matter, BTC matter, Lordship, item.
What? This is item number
No, this is 20, Lordship.
20.
Just make one submission regarding item number 8, Lordship.
Don't make any submission. I passed that order. That order shall remain as it is.
No, Lordship, just,
No, I'm not going to hear. When you don't come before this court prepared, face the consequences.
no, Lordship, in the.
There's nothing out there.
The admitted amount has been already received. In the order sheet, it was reflected, but they are denying the same. I'm saying that admitted amount has.
You
been-
say that you have only paid 85 lakhs. That's what you said.
No,
Out of 2 crores 40 lakhs, you
filing of the affidavit, 2 crores 40 lakhs was paid, and that was admitted by the council on 24/6/26 order, Lordship.
no, you have to show me. You have failed to show me. And Miss Madam, no, that order remains. That council is not there. I'm not going to change that order.
No, no, just I want to intimate this.
No,
court that
sorry. Forget about that. Now
as
the
they
question.
admitted,
Now what is about this case? Come to the facts of this case.
some time as they have paid legal opinion in connection with the disputed amount, Lordship.
Don't worry. Legal opinion, I will give it by passing a judgment.
Lordship,
Now come to the point.
that's why, Lordship, I'm praying for some time, and legal opinion has been already given yesterday, Lordship, and according to the legal opinion, they will act to comply with this honorable court's order regarding the disputed amount. The admitted amount, the BTC authority has already paid to the petitioner,
No, my
Lordship.
lord,
Regarding the other disputed amount, they are going to act, Lordship.
the issue is slightly different here, my lord. What had happened?
No, the disputed, the amount pertaining to 7 crores, 14 lakhs, 18,171.
Right.
Has that been paid to the petitioner?
My lord, the amount which is pending as of now is 3 crores 86 lakhs.
So you got the 7 crores.
No, the 7 crores have been paid.
So that is
My
what
lord.
I am saying. You say that it has been paid. I said you got it. It is one means the same. Yes. So you have got 7 crores out of 10 crores, 96 lakhs. Now the remaining amount you have filed the writ petition. Why?
Now, my lord, what had happened initially when the amount was not paid in its entirety, we had filed a writ petition before this honorable court on an earlier occasion. That writ petition, my lord, was disposed of with a direction to the BTC to verify my claims and to thereafter make the payments. Then, my lord, the payments were not made, pursuant to which we were constrained to file a contempt. Now, my lord, the affidavit was filed by a functionary of the BTC. That might be relevant for your lordship's purposes, my lord.
No. I now remember this case. Go to the civil court.
No, my lord, if this matter.
Go
on-
to the civil court.
My lord, absolutely, my lord. If,
Take those affidavits and make it a part of the record or do whatever. Go to the civil
my
court.
lord, just my lord, a 2-minute submission, if I may.
No,
make, my lord. A 2-minute
That is
submission.
what, well, that day only I wanted to dismiss it on 25/2026, when your senior was here.
My lord.
When your senior was appearing,
Yes, my
on
lord.
that day only I wanted to dismiss it.
My lord,
But on account of paucity of time, I could not.
Lord,
Today
as-
I have ample time.
my lord, as against your lordship's order.
Hello. Division bench?
No, my lord, if I may be permitted to
Division
make,
bench.
my lord, just be permitted to make a statement, your lordship will dismiss this as a deemed fit, my lord. The fact was,
Why
my
haven't
lord,
you filed your affidavit?
they have filed their affidavit.
Where?
The file.
They filed their affidavit as against the order, my lord, of 8th of May, where they said that they will not file an affidavit. But eventually, my lord, they have filed an affidavit.
When
Where-
they have filed?
My
It is
lord,
not on record.
17/6.
It is, my lord, we had received it on 18, my lord, they had filed it. And paragraph number 10, they say that why I should not be paid the remaining money is because it will be unjust and unfair. The aspect is, my lord, page 28 and 29, my lord, for a moment, my lord. I'll not trouble this court.
I still remember, your is as regards the rates.
rates. And that rate
And that
exactly,
rates, show me a document whereby rates were fixed at the time when the supply was to be made.
my lord.
Show me that document.
My lord, the document, if I can
No,
rely on the
show me
inquiry
that
committee
document.
report, the
No,
inquiry committee report, my lord, their report,
Mr. Sharma,
lord.
that doesn't align.
my lord.
Show me the document that at the time when the supply was directed to be given to you,
My lord.
there was a rate fixed.
My lord, that rate, my lord, that annexure 1 and 2, my lord, I humbly.
I'm not on that.
My lord.
Show me the document where a rate was fixed at the time when you were asked to supply. The supply order contained the rate. That's it.
My lord, may kindly come to page 53, my lord. Page
Page?
53. Although it might not qualify as a document, your lordship has got, but
not
the-
this.
the observations.
No,
the inquiry committee, my
no.
lord.
You see, that is why
My
I'm
lord.
very careful while passing an order of making payment,
My lord,
because
my lord.
what happens later on the garb of contempt, exercise of contempt jurisdiction, the officers are forced to file affidavits. I'm not on that. My question is, where in your supply order there is a direction for making payment? What is the rate? That's the case. They have now later on found that that rate was unreasonable. So whether it is reasonable or unreasonable is a question of fact which needs to be decided before the civil court, not here.
My lord, notwithstanding the fact that it was a contractual arrangement.
So what?
My lord.
There has to be. In fact, that contract, you should have returned back the 7 crores. Without fixing a rate, you have supplied. You may be entitled to quantum merit. Quantum merit will come under Section 70 of the Indian Contract Act. You need to go before the trial court, not here.
My lord.
So you do one thing. We pass an order directing you to refund the amount of 7 crores. Yes. Refund the amount of 7 crores.
Well, that has not been disputed also, as against our claim.
So they have fixed the rate.
What, my lord?
They had fixed the rate, therefore they say that it is 7 crores.
My lord, that could have been 5 crores also, depending on the possible.
Understood.
My lord.
My question is, they have fixed this 7 crores. Your claim was 10 crores 96.
My lord, my lord.
They have paid you, they say that it is 7 crores 41 lakhs.
Then they stopped.
It's okay.
My lord,
They
yes.
say so.
They say so.
On the basis of the rates which was as per the authority's assessment.
My lord.
The earlier rate which was given was not as per the government. That is what their stand is. In the impugn order, that is the stand.
They said it is slightly higher than the market value. That is the word they have taken, my lord. They have not
So
objectified.
can this
my lord.
court decide what is higher than the market value in a writ proceedings?
They obviously won't, my lord. My lord, the aspect, my lord, which has come into your lordship's perusal, my lord, that's page 53. My lord, for a moment, my lord, just
No, that I'm not going to look at.
the only.
Let the division bench look at it. Let me dismiss it. You don't want to file a civil suit also. So therefore, I don't grant you the liberty also.
Page 53.
Whose name you want?
52, sir.
The senior's name, your name, whose name? Your name. Dismiss at your hands. Heard Mr. M. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. N. Chaudhary appears on behalf of the respondent numbers 2, 3, 4, and 5. The present petition has been filed challenging the actions on the part of the respondent authorities in reducing the amount to which the petitioner claims to be entitled to on account of supplies made by the petitioner. It is the case of the petitioner.
My lord, just if I may interrupt, my lord, my senior friend here, my lord, had just submitted that page 70. I ought not to have put it for your lordship's calculation, my lord, page 70.
Yes.
That the addition of the serial number from 1 to 22 comes to 85,000. Your lordship sees, my lord. That is what has been just informed, my lord. Further, in respect of 10th house materials, the rates quoted by Messrs. Malina Enterprise, Kokrajhar and Messrs. Were accepted and approved as follows. So number 1, serial number 1 to serial number 22, my lord, it adds to 85,000 as has been.
So, how does it matter?
No, if the rates have been approved at a prior point in time, my lord.
When did you supply?
My lord, 2020 onwards, my lord, after 2020, my lord. The NIT was issued, my lord, the NIT was dated 2019. And there was a modified order, my lord, at page 29, which is 31/12/2020.
Where?
My lord, the modified work order is at page 29. This is where you have failed, my
Where is
lord.
your work order?
My lord, 29, my lord, this is where we actually,
Where is the, your work order is what?
my lord, it was
Page
initially
26.
28 and 29. my
Page
lord.
26. You are not claiming as regards this amount?
No,
Page
my-
26.
Yes, my lord.
You are not claiming.
I'm claiming, my lord.
So if that is claiming, this is done in 2019.
My lord.
The rate was fixed as per that. Was
Yes.
any rate fixed then?
85,000, my lord.
Was any rate fixed in 2019 when the supply order was directed?
My lord, this is dated 2019, my lord, this
So,
work order.
But this document is of 2020.
My lord, no, the subsequent document, my lord, this,
No, page 71 is of 2020.
my lord.
So
my-
therefore,
My lord.
this is how the government is being swindled of by these officials. Work order of 7/3/2020.
My lord, 7/3/2020. That was thereafter modified at page 29, my lord.
That is what 7/3/2020. Where is the work order of 7/3/2020? Supply
There-
of so and so.
The relevant
Please
annexures, and I
supply the
understand.
GIC so and so to the distributed to the people so and so demand. The terms of alia, the items to be supplied as per specified will be the replaced supply must be completed within 60 days from here. Payment will be made on receipt of the beneficiary list and so will be made. Forest department will no longer be responsible of so and so, direction on so and so.
There was an omission on our part, my lord. Annexure 1 and Annexure 2.
Show me the NIT, the tender.
My lord. The NIT, my lord, is at page 27.
Show me the tender of 11/2/2020.
It's not a part, my lord.
Huh?
It's not a
Then?
part. my lord.
Because I think we need to place this before the CID for inquiry. Because it's high time. This is what is being done. It's a very serious offense.
Upon I tender to socket, page 28 of socket, page 28 of 11 to tender to court. আমি NIT লাগাইছি বলে কোর্টে রিটার্ন করেছি সেটা ঠিক আছে না এটা আপনার 24/12 একটু আপনার NIT 2 বা 27 কি থাকে 11 to 9
Which is the impugn order?
My lord, the impugned order, my lord, is at page 100, my lord. 2011, 2025, my lord.
Being agreed by the amount of rupees so and so. No. The present petition has been filed by the petitioner assailing the order dated 2011/2025. Whereby the claim of the petitioner to the tune of rupees 10 crores 96 lakhs 14,488 was reduced to rupees 7 crores 10 crores 10 crores 96 lakhs 14,488 48. was reduced to rupees 7 crores 14 lakhs 18,171. It is the specific case of the petitioner that the said amount of rupees 10 crores 96 lakhs 14,488 was admitted by the respondents in the affidavit filed in contempt proceedings, contempt case civil number 476 oblique 2022. And therefore, the respondents later on cannot resile from their stand in their affidavit and reduce the amount. That's your case.
My case, my lord. At page 76, they have specifically admitted, my lord. Page 76, my lord.
At page 76, that is what?
Yes, my lord. Yes, my lord. That it is an admitted account. Yes, my lord. That is the only.
This court have duly heard the learned counsels, have duly heard the learned counsels appearing on behalf of the parties and have perused the order dated 20/11/2025. From a perusal of the impugned order dated 20/11/2025, it is seen that pursuant to the order passed by this court on 24/11/2021, an inquiry committee was constituted by the order dated 4/10/2024 in order to examine and verify the claims of the petitioner with respect to the supply of GCI seats, tent house materials, and blankets, which were claimed to have been supplied by the petitioner. The inquiry committee examined and verified the claims of the petitioner, and it was found that the petitioner delivered materials as per the terms and conditions of the supply order issued in that regard and as per the report dated 11/2/2025 submitted by the rate verification team. No, full stop. Supply order, full stop. It was further mentioned that as per the rate reports dated 11/2/2025 submitted by the rate verification team, it was found that the rates approved against one set of tent house materials, which was rupees 85,194, was on the higher side. As per the rate verification team, the rate of one set of tent house material should lie in between 13,975 to 19,170. Be that as it may, the respondents have filed upon verification arrived at that the petitioner is only entitled to rupees 7 crores 14 lakhs 18,171. The case of the petitioner in this context is that in the affidavit which was filed by the respondents, by one Sri Akash Deep,
Deep, my lord. Principal Secretary, my lord.
Principal Secretary, Boroland Territorial Council. It is mentioned that the petitioner was entitled to rupees 10 crores 96 lakhs 14,448 after due verification. And therefore, the respondents cannot reduce the said amount. This court finds it also relevant to take note of that the petitioner was issued the work order
7/3/2020, my lord.
on 24/12/2019. Thereupon, the petitioner was issued the work order on 7/3/2020
My lord, page 28.
for supply of the GCI seat, Tata Shakti tent house materials and blankets. What is the quantity of supply to be made as by the petitioner?
Yes, my lord. 12/02, my lord, page 26.
Is not mentioned in the supply order dated 7/3/2020,
Not mentioned, my lord.
as well as also in respect to the subsequent order dated 31/12/2020.
28 and 29, the omission might lie on our part because your
I'm
lordship.
not on that. I'm not
That is
concerned.
my mistake, my lord. So,
The subsequent documents, which are Annexure 5 and 6, are documents forwarded by the additional PCCF cum CHD Forest BTC. Forwarding the bill and challan, advice slip requesting sanction and release of funds. This court also takes note of that the Secretary BTC had issued an order on 16/3/2021, thereby according sanction and release of an amount of rupees 1177,11,611 to the CHT Forest BTC Kokrajhar for bill for supply of GCI seat, solar torch, tents, and woolen blankets to be used by the frontline staff of different forest divisions of the BTC. Against the proposals which were submitted by the CHD Forest BTC dated 8/3/2021. Be that as it may, it appears that the petitioner, having not received any amount, the petitioner filed a writ petition before this court, which was registered and numbered as WPC number 2950/2021. The learned coordinate bench of this court by an order dated 24/11/2021 disposed of the said writ petition, directing the Principal Secretary BTC to make necessary inquiry and verification into the claims made by the petitioner, which were stated to be admitted by the BTC authorities, and thereupon to make payment in terms with the guidelines laid by the full bench of this court in the case of Tamser Ali and others versus State of Assam and others reported in 2008 4 GLT 1. It reveals further from the records that on account of payments not being made, a contempt proceedings was initiated by the petitioner, which was registered and numbered as contempt case number 476/2022. In the said contempt proceedings, the contender number
Akash Deep only, my lord.
number 2
My lord.
filed an affidavit wherein he admitted that upon due verification, it was found that the amount of rupees 10 crores 96 lakhs 14,488 was payable by the Boroland Territorial Council to the petitioner. And also admit and further stated that out of the said amount, 10% would be paid in the year 2025-26. The records further reveal that in pursuance to the said amount, an amount of rupees in pursuant to the said affidavit, an amount of rupees 1 crore 14 lakhs 18,171 was paid to the petitioner. Subsequent to the filing of the affidavit by the said Sri Akashdeep, an inquiry committee was constituted on 4/10/2024, wherein inquiry was conducted as to whether the petitioner had duly supplied the goods, and further as to whether the rate at which the petitioner supplied the goods was reasonable. It was found upon inquiry that the rate at which the petitioner had duly supplied the goods, but however, the rate at which the petitioner supplied was unreasonable, inasmuch as it is the report of the rate verification team that the rate of one set of 10th house material should lie in between 13,975 and that's 19,170. In the context, in the above context, this court, the learned counsel appearing on behalf of the petitioner submits that on account of the admission on the part of Sri Akashdeep in the contempt proceedings, this court should pass a direction upon the PTC to make the payment. First, it is well settled that a contempt proceedings cannot be initiated against the BTC. The contempt proceedings have been initiated against officials who, in their personal capacity, had submitted the affidavit. First, it is not the stand of the BTC in their affidavits which were filed in the writ proceedings or in the present proceedings that the petitioner is entitled to the said amount. Under such circumstances, the stand which have been taken by Sri Akasti is by filing an affidavit in a contempt proceedings is a stand personally taken by the said official. Next. This court also finds it relevant to observe that the question as to whether the rate at which the supply was to be carried out is the actual rate or the petitioner had, or the rate which is now being permitted is the actual rate, is a question of fact which needs to be adjudicated in a forum wherein evidence can be led. Merely on the basis of an admission by an official in his personal capacity. This court cannot direct the BTC to make payment of the amount of rupees 10 lakhs, 10 crores, 96 lakhs, 14,488. This court therefore is not inclined to exercise the jurisdiction under Article 2 to 6 of the Constitution, for which the writ petition stands dismissed with cost quantified at rupees 1 lakh upon the council.
My lord, if your lordship may, this was a bona fide litigation, my lord.
There's no bona fide. I told you on the first day itself, it is an absolute bogus. I asked you to go to the civil court. You did not.
No, to try our luck here before this court, my lord. So
Don't try your luck.
It was a bona fide litigation, my lord.
No. Bona fide and luck is both different things.
True, my lord, true.
Yes.
We wanted
One is bona fide. Yes, you have a case and you honestly feel that you have a case. Yes. But you try your luck in the High Court.
My lord, we wanted to try.
Does it sound good, Mr. Gogoi? Huh? Mr. R. Gogoi, have you ever heard of somebody making a submission before the court that let us try our luck in the High Court?
Try to impress upon this court, my lord.
Isn't it it's a bit contemptuous?
My lord, we wanted to impress upon this court, my lord, that
No,
we have a case, my lord.
try your luck in the High Court.
As to being able to satisfy this court, my lord. Not luck before this court, my lord. I think my luck
That's
to
your
satisfy
word.
this court.
I never put the word in you.
Impress this court, my lord, on behalf of the petitioner, my lord, if that aspect.
Chalo, কষ্ট না লাগে।
And
আর এই তো দিব, liberty to দিব. The liberty during the pendency of the liberty আছে। That order was passed in 2025, na? When was this order passed?
25.
25.
25.
November.
It's 7 crores.
The 7 crores, my lord, it was subsequent to an order of this honorable court, my lord, that was 25.
What is the impugned order date?
My lord, 2011-2025.
Okay, you have the time. Okay. So this court, however, observes that before parting with the record, this court, however, observes that the dismissal of the instant writ petition is on the ground of not entertaining the writ petition. The reasons aforementioned. Under such circumstances, it shall not preclude or prejudice the petitioner in any proceedings initiated before the competent court of civil jurisdiction. Further to that, the observations made in the instant order, the judgment, shall not also affect the petitioner in such future litigation. Now we'll take the item as the last item of the day. Take it as the last item of the day.
Fine, last. Ah, bless.
May it please your lordship. The petitioner is a class 1A contractor, my lord. The completion certificate was issued and thereafter, my lord. The completion certificate was issued and thereafter, my lord, the fund was transferred in some other, my lord, contractor's bank account. My lord. We made a representation and but the amount could not be credited. In one of an earlier instance, my lord, same thing happened and they had credited the amount in our account.
Well, the work was executed on behalf of the, my lord, GAD department. And my lord, it was finally executed by PWD. And DDO is the PWD department, my lord, executive engineer. Here, my lord, though amount was sanctioned, FOC was issued, my lord. Probably it appears, my lord, it has gone to the wrong account or something has happened, my lord. So let the two department, my lord, resolve the issue. Ultimately, it's 1,37,000 or 74,000. 76,000. So we will give a time, my lord, time frame to be resolved. Affidavit we have filed on behalf of both the departments. No dispute that amount was already, my lord, released, but probably it has gone to some wrong account. Or if, my lord, wrong account number has been provided by the petitioner, that is a contractor or supplier, in that case, it will be her or his fault.
That is not possible, my lord, because we have been regularly carrying
I
out
have
works.
asked a specific question in my order
My lord.
dated 22/5/2026.
My lord.
What do you stand?
What's the name? Who knows it? My lord, I'm not aware of that order.
This the said affidavit has been filed on behalf of the GAD on 17/6/2026.
My lord.
17? Illegally. Be filed by so and so.
Yes, respondent one.
This court further directs the Public Works Department to apprise this court by way of instructions on the next date as to whether the respondent department had details of the bank account of the petitioner prior to the release of the amount
My lord.
in their accounts, more particularly taking into account that the petitioner is a Class 1A contractor.
It will be there, my lord. Of course, it will be there. Then, my lord, that I can place, my lord, day after tomorrow or Friday. It will be there.
Evening? No,
Today.
today.
Yes, I can place
Because
it.
this is an instruction which we sought on.
Yes, it will be there in the record, my lord. I will place it.
Enough.
May I please, your lordship? Well, the petitioners, my lord, prayed for, my lord, LOI, my lord, for opening a, my lord, nursing institute, my lord. Now, my lord, as per the norms, my lord, they have to, my lord, ready the infrastructure within 3 years after the LOI, they get the LOI, my lord. Then the LOP is given, my lord. My lord, the respondents in their affidavit, page 58, my lord, has raised two issues. Page 58, paragraph 5, my lord.
They say
What they say, my lord, that the land is in the name of, my lord, the petition number 2, who is the, my lord, actually the, my lord, the chairman of the institute. And, my lord, the parent hospital, my lord, that is the bed strength, etc., has not been certified. So, my lord, we have filed a reply, my lord, saying that, my lord, so far as the, my lord, land is concerned, my lord, the chairman has already, my lord, initiated the process, my lord, for transferring, leasing the land, my lord, because the permission is to be obtained. So, therefore, we have asked for, my lord, permission, my lord, to grant lease, my lord, get the lease done. And secondly, my lord, so the bed strength, etc., concerned, it is they, my lord, who have to certify, my lord. It is their certification is necessary, my lord, the departmental certification, my lord, by the, my lord, Joint Director of Health Services, because they are the one who will be certified. Otherwise, my lord, we have indicated, my lord, initially they had asked us whether, my lord, we have that, my lord,
no,
hospital.
they are not. Parent hospital, bed strength, full function and operation of parent hospital to be certified by competent authority. Who is the competent authority?
Competent authority will be the Director of Health Services, my lord, because under the Clinical Establishments Act, my lord, the
So you are to certify.
exactly not me, my lord, because here, my lord, we MERT department, Medical Education and Research Department, they have to apply for the LOI from the MERT department, my lord. That is a different department, my lord.
You have to ask that. It is not they. They have bifurcated the department into two wings.
Yes, my lord.
One is the education and the other is the
Department.
health department. So there, he may appear. He only appears, but that's a different
Yes, my lord.
department.
My
So
lord,
Mr.
because
Dotto, you were right in pointing out the finger upon the council, but not the department.
Malad, has to be made, Malad, the medical department is a party, Malad, so therefore, Malad,
No.
you have to balance the true, Malad, the health.
So these are the two things which needs to be taken care of. So therefore, they have rightly not guaranteed you. So nothing remains in the repetitions.
So we allowed to implement this, Malad, the
Why should we?
health services.
There's a different cause of action. What you have got your information. That is the why you have come before the court.
True, Malad.
You've come before this court only on the ground that these are the things that you have submitted the application. You will lose out the year because if they have not granted the permission. The two reasons they have given. One is that the land does not belong to you. You are in the process of getting it.
Right.
So you also know that without the land belonging to you, you are not in a position.
Malad, Malad, page 44, Malad, it says, Malad, we can get the infrastructure ready within 3 years, Malad.
Whatever may be. So therefore,
And-
whatever may be, the land has not yet been transferred to you.
Well, that's there, Malad, because Lordship, I see page 44, Malad. So, where the land is concerned.
Whether, Mr. Doctor, you have to understand whether the land is required to be yours or not as per law.
Malad, page 44, Malad, that's why, Malad. It says ideally, Malad, it should be in the name, Malad. To open a nursing home, page 44, Malad. Nursing, Pharmacy, Allied Health Science Institute in Assam.
To open a nursing so and so, the applicant must ideally
Ideally,
put the required as per the direction of the respective in the name of the institute itself and should have permanent patta
And position, Malad.
and possession.
Malad. So ideally,
So,
Malad.
no. It may be in your name,
Malad.
but ideally it should be named the name of the institution.
True. Ideally, something, Malad, akin to preferably, it should be in the name of Malad.
Has to be in the name. No, ideally it should be in the name of the institution.
Yes, ma'am.
But it may have to be, it may be still in your name. So therefore you don't have it. So this is one. The other is you have to get it from the director of whatever may be. Get it and file it properly. They will consider.
Well,
It's the only way out. Heard Mr. M. Dotto, the learned senior counsel, assisted by so and so appearing on behalf of the petitioner, Mr. D.P. Bora, who appears on behalf of the respondent numbers 1, 2, and 3. The present writ petition has been filed by the petitioner being aggrieved by the delay in processing the petitioner's application for
LOI, Malad, letter of intent.
for the letter of intent, for issuance of the letter of intent to the petitioner. This court, by an order dated 29/4/2026, while issuing notice, directed the respondents to bring on record their stand by filing the affidavits as to why the petitioner have not been issued the letter of intent. An affidavit has been filed by the respondent number 2, wherein it is mentioned that on account of two reasons, the petitioner's application could not be processed. First is the land is in the name of one Mosbil Hussein Borbia and not in the name of the institute. And secondly, the parent hospital bed strength, full function and operation of the parent hospital has to be certified by the competent authority as per the Clinical Establishment bracket Registration and Regulation bracket close Act 2010 and the rules framed therein under. An affidavit in reply has been filed by the petitioner to the effect that steps are being taken for converting the land for acquisitioning of the land
Creating lease, madam. Lease.
Uh.
Para 3, madam.
for leasing out the land in the name of the institute. And for that, permission have been sought for. Further to that, it is also mentioned that it is the respondent authorities who are required to provide the said certification by the competent authority, certification as per the Clinical Establishment Bracket Registration and Regulation Act 2010 and the rules framed therein under. Mr. D.P. Bora, the Learned Counsel, submits that the said that the competent authority would be the Director of Health Services, and the respondents in the present proceedings is a completely different department. Taking into account the above, this court therefore disposes of the present petition with the observation that the petitioner would be well advised to take appropriate steps for having its name, having the petitioner's institutes, having its name in respect in the land records, wherein the proposed nursing home, nursing
College, madam.
nursing college
Right.
is to be set up. And further, the petitioner may approach the appropriate authority for getting the certification in terms with the Clinical Establishment Registration and Regulation Act 2010 and the rules framed therein under. So accordingly, the petition therefore stands closed. Those who have missed the bus in the serial, their matters will be taken at the last item. You may have to wait till 5:30. Yes, what is this?
No, we have filed our rejoinders to the affidavits in reply filed by the private respondents, my lord. And my lord, the claim of the alleged first wife, which is there, my lords, on the basis of her affidavit, she has filed a marriage agreement, my lords. If your lordship will kindly have page 79, my lord, which is the affidavit filed by the private respondent. Respondent number 7.
My lord, in this regard, I would like to file a reply, my lord, to their affidavit, if your lordship permits.
Lords, at page 88 is the marriage agreement, my lords.
What page you are referring to?
It's page, it starts at page 79.
It starts at page 91.
Because in my page, in the page number copy that they have given, that is 79, my lords.
No.
There are two affidavits, my lord. Affidavit in reply filed by the respondent number 7. This is Saira Sultana.
My lord, I am for respondent number 7.
But wasn't the divorce proceedings initiated against the respondent number 5?
No, the departmental authority has filed the affidavit, and at page 47 of their affidavit, my lords, is the divorce certificate, which is issued by the Muslim Marriages and Divorces Registrar and Sadar Qazi, Gauhati, in the year 2017, my lords.
Of? Between?
Of their marriage, my lord, the deceased and the first wife, that is the respondent number 7. And this marriage agreement, if your lordship sees, my lord, it's a one-page affidavit. There is one page.
Forget about that, but there is a divorce.
There is a divorce, which she has not challenged till now. Now, even in the reply that she has filed, she has only said that it is without her knowledge or consent. She has not even made the statement that I have challenged it or I am going to challenge it in any court of law. Because that, my lords, right or wrong, there is a divorce certificate, my lords, 2017. And it is after that 2017 marriage that I was married to the deceased under the Special Marriage Act. That is how the things stand as of today, my lords.
You married when?
I married, my lords, in the. Our marriage was under the Special Marriage Act.
13/5/2015.
Yes.
But
13/5/2015.
13/5/2015.
Under the Special Marriage Act. Now,
Isn't it required for you to have a declaration that there is no marriage?
No, my lords. Rather, I would say the burden lies on them, my lords, because in 2015, let us say I got married with the with the deceased, my lords. Now, ordinarily, my lord, even for a Mohammedan employee, my lord, it would be an act of misconduct if the permission is not obtained from the departmental authority, my lords. It's an act of misconduct. Supreme Court has held that in the Khurshid Ahmed Khan's case, my lords.
What does it say?
It says that, my lord, ordinarily, if the permission is not obtained, my lords, for the second marriage, even for a Mohammedan male, my lords, who is a government employee, it's an act of misconduct. And that will not invalidate the second marriage, but it's an act of misconduct. Now, she at that time, my lord, definitely was the first wife, my lords. So during the subsistence of the first marriage, the deceased got married to me in a second time. That is why the marriage took place, my lord, under the special marriage.
But after it's a Muslim, I think you can marry twice.
Yes, that it's not affected under the personal law. But for whatever reason, my lord, they got married under the Special Marriage Act. So the Special Marriage Act, my lords, I got married.
What do you say about the full bench judgment
of Junu family? No, my lords, the fact remains that there is a divorce certificate which is there on record, which is there before your lordship of 2017. Now, my lords, under that, as per that certificate, which has not been challenged by her till date in the last 9 years, my lord, that marriage of hers is dissolved. Now, she has to go and obtain a declaration. Supreme Court has said in Rameshwari Devi's case, my lord, that the parties need not wait for the civil court to get the family pension and the other benefits. It would be a long drawn affair. That's the words of the Supreme Court. Now, my lords, in this case, her marriage stands dissolved with effect from 2017. That is, as on the date of his death, my lords, in 2022, I am the only legally married wife, this petitioner. So now, my lords, why I was saying that the act of misconduct, my lord, that she should have or could have made that complaint before the departmental authority that, look, here I am the subsisting, my lords, and legally married wife, and during the subsistence of the marriage.
She also gets a next of kin certificate.
She also has got, even the mother has got, my lord. And the mother has got a certificate which is showing his brothers also as the next of kin. So there are, as on date, 3 next of kin certificates. One that I have got showing myself as the wife.
How many children you are having?
No, my children are not with the deceased. My children are not with the deceased. That is from my first marriage. Yes. So both of them were married. Both of them were divorced. And
So
from
with
this,
you, the pension will finish.
yes, with us, with me, the pension will finish. And as far as the children from his first marriage are concerned, my lord, those are all major. One daughter and one son are there. They are major, so they are not entitled for any pension. Now, the only aspect is that, my lords, she has not challenged this.
What about the unmarried daughter? You have an unmarried daughter? No.
Yes, madam. Unmarried daughter and one married daughter and one son, my lord.
Married daughter won't get it, but unmarried daughter is there.
No, my lord. Only one daughter, she is married. My lord, I would like to point one thing, my lord. Regarding the their marriage, it was solemnized under Special Marriage Act. But I would like to show the section 4, the conditions relating to solemnized special marriage, my lord. neither party has a spouse living. 4A, my lord, neither party has a spouse living. Neither party is incapable of giving a valid, I'm pointing out section 4A, my lord. Under the special marriage, a second marriage would not have been, could not take place, my lord. Because at the time of that marriage, he was, petitioner was having minor spouse. And my respondent number 5, respondent number 7's husband was also having spouse. So their marriage is also
Okay. What
invalid
happens
by the
after
second.
2017 in view of the
After
No.
2017, my lords, the
if, just for example, let us take the condition, because you are doing it under the special marriage.
yes,
You are claiming your right on the basis of the special marriage.
yes,
The Special Marriage Act categorically mandates that there cannot be a life spouse.
Lordship.
Now, what happens if once the marriage is there, thereupon is it a case of nullity? No.
No, my lord, in my respectful submission, the marriage agreement that they have now relied upon, which is in the year 87 or 86, that marriage agreement is not even a valid marriage under the Muslim law. That may or may not fall for your lordship's consideration for the grant of family pension. Because lordships are aware, my lord, where there is a continuous habitation and all those things are there, then the family pension can be granted. Lordships have gone through those cases now. But my lord, in the case of a Muslim marriage, and here, my lords, what document have they relied upon? This is a one-page affidavit of it's a one-page registered document of the year 1986.
It's okay, but the fact
Fine.
also remains that you are also relying on the 2017 divorce.
Yeah, yes, I'm relying
The
upon
moment you are relying on the divorce, there is a presumption there is a marriage.
presumption for the marriage. But for whether, my lords,
Therefore, when you are you can't rely on the 2017.
my lords, this document has been placed on record by the departmental authority. my lords.
Whatever may be.
Yes.
So there is a divorce,
There is
rightly
a-
or wrongly.
There,
Divorce
yes,
is there.
there is a divorce.
When there is a divorce, there is also a presumption that there is a marriage.
Presumption may be for the purpose, for the limited purpose of grant of service benefits, yes, my lord, but it cannot affect the validity of a marriage under the Special Marriage Act. Because in that case, my lord, in every case where there is a Special Marriage Act, marriage between two individuals, any person can come forward with a claim, any of the spouse can claim that, look here, I have been cohabiting with this person from this number of years, and therefore I am a living spouse
There's
for
no
the
quarrel
purpose.
with the proposition also
Lordship.
that in the year 1986, there was a marriage agreement.
That, my lord, that is,
Rightly or wrongly, marriage agreement was there.
maybe, my lord.
They have been cohabiting.
Yes.
Out of that, there were a child, a son and a daughter were born,
Lordship.
and they have now attained majority.
Yes.
So no quarrel with that, these facts.
Yes.
So therefore,
only
in
aspect
the
is the
eyes of
validity.
law, and along with that divorce, in the eyes of law, there is a marriage which can be presumed to that effect.
Presumed. But not for the purpose of the Special Marriage Act. As far as the validity of my marriage is concerned, because that, my lords, where a marriage, for example, my lord, there is a registered marriage, my lord, that they have concluded. Now, my lord, under which
therefore,
act?
this court has to go into
Lordship.
the question of fact as to whether there was a cohabitation
Yes.
between the respondent number 5 with so and so for
Seven.
all these years. Seven, and there was the people understood to their effect. Isn't it a question of fact?
It's a question of fact, but that question of fact
My
will be
lord,
limited
I
for
want to
that
add
pension
one
purpose.
point, my lord. After this marriage agreement, there was also a social marriage which was solemnized under Kazi.
Where is it?
But unfortunately, since so many years have passed, my client could not.
Where have you stated in your affidavit?
No, my lord.
You can't say, madam, it is, I don't want your personal opinion or information.
That
Yeah,
is
there
true, my
has to be
lord.
something in the affidavit.
Yes, that is of course true, my lord.
Then if you are not making,
now-
don't make the submission beyond
My
your
lord,
records.
That is why, my lord, since they have given this affidavit, your lordship may kindly permit at least 10 days time so that I can bring it in records. I may be allowed to file the affidavit in reply to their rejoinder, my lord. Regarding, since they have challenged my marriage, my lord.
Madam, Ms. So-and-so, the learned counsel appearing on behalf of the respondent number 7 submits that in view of the stand which has been taken by the petitioner in their rejoinder affidavit, she would like to file a rejoinder taking into account certain important facts are required to be brought on a court. Taking into account the above, list this matter on 17th of September 2026. In the meantime, the affidavit in reply, a rejoinder be filed by the respondent number 7.
Woodlands, ma'am.
You have no business out there. You are the mother.
May it please your lordship.
Yes, what is this?
This matter pertains to non-payment of contractual dues, your lordship. Your lordship, the respondents are disputing the payment on the ground. If your lordship may kindly turn to paragraph 5 of their affidavit in opposition, page number 91, your lordship.
Yes.
Relevant at page number 92, your lordship. If I may read, your lordship, from the top. Petitioner has been claiming that he had completed the said 8 numbers of work. The completion certificate he had submitted seems to be fake and fabricated, as because the completion certificate should have to be signed by the concerned executive engineer, not by the account officer as mentioned in the completion certificate.
What work did you do?
Your lordship, I am a class 1A contractor.
What work did you do?
The
The 8 works which you have done.
These were related to roads, repair of road, construction of roads.
Under which project?
PWD, your lordship, there were various projects. This is
What type of project?
at page 7, your lordship, I have mentioned on of my writ petition.
Can't you see what are the projects?
Lordship, this is under division annual plan for 2001, 2002, providing WBM patching, PS, PC and SC grade 2. Then
Understood. These are work orders where work completion you have carried out.
Yes, your lordship.
These are works under what they are. These works which PWD does.
Yes.
These are under some scheme.
No, lordship.
Then,
lordship, these were formal work orders issued in respect of some means different kind of works, your
so
lordship.
they don't deny the work orders.
No, lordship.
They don't deny. They only deny the completion certificate,
Lordship.
which have been issued by the executive engineer.
They say that it is issued by the accounts officer, not by the executive engineer. Your lordship, if your lordship may kindly see my completion certificates at page number 35, your lordship. The writ petition.
Yes.
On the left bottom, your lordship, it's signed by the accounts officer. On the right bottom, it's signed by the executive engineer. Now they are saying that it is not signed by the executive engineer. So they are denying it, saying that they are fake.
Yes, Mr. Kumar.
Lordship will see para 4 also for affidavit. Para 4 as well as para 6.
Para 6, we have looked into it.
Para 4, madam. 4 and 5.
Page.
Page, my lord, 91, running page 91.
Then to submit the original copies of 8 bills, completion certificate, original agreement, PWD so-and-so as required for the demand submission. As reported by the concerned executive, although photocopies of 8 bills, as mentioned by the petitioner, are available in the divisional office, but their guidelines could not be established in absence of the original. PWO means formal
Work order, it is a-
photographs, inspection, and so and so. But why do you say that?
Lordship will see 99 now. In 2002, 2003, this was the format for completion, or issuing of completion certificate, my lord, of work orders. Lordship will see page 99. And now Lordship will see, my lord, the completion certificates, the petitioner has annexed. It is only issued by the executive engineer, not by some accounts officer. And here Lordship will see all are type paste, my lord, 43 onwards in the writ petition.
Or 35?
No, sample copy is at page 99 in the affidavit, my lord, part of the affidavit. In 2002, 3,
This is a, for which period?
2002 and 3, my lord.
My goodness.
2025, it has been
That
filed.
is why. Why have you filed so late?
Lordship, we are again and again representing, and if
No,
your
no,
lordship may
no,
kindly,
Mr. Counsel, no.
lordship, for 1 second, if my lordship, if I may
No,
just take my
I
lordship.
cannot allow. This is my, I'm very, 2000, obviously that is why 2002, 3, if you are asking the money in 2025 by filing a writ petition, this court cannot allow them to verify because the documents are not there. They may not. After 23 years, how do we, this court can direct them to look into it?
Lordship, there was a
Well-
direction from the chief engineer to the executive engineer in the year 2023 to submit the demand proposal against the works. It's at page number 83, your lordship.
It's under my lord scanner of the my lord CM vigilance cell, my lord. So far as my lord Dibrugarh is concerned, during this period, my lord, several my lord such work orders were issued. Completion certificates have been produced. Despite my lord, without carrying out any work, my lord. There was this big scam, my lord, of maintenance. Every year, my lord, bills have been, my lord, released in the name of maintenance without there being actual, my lord, work order, completion order to few, my lord, contractors. He is one of those, my lord. Pradeep Kumar Das.
Lordship, but they haven't
cannot
produced
deny that.
any
It's
documents
under
with
my lord's
regard
scanner.
to
That's why,
that
my lord, all
there
these
is
issues.
any vigilance
Because it
against
is
me,
maintenance
your
and
lordship.
CM vigilance inquiry.
Yes, some inquiry is going on, my lord. Petitioner
Wait,
is a part of
wait,
the.
wait. Is it based on your affidavit?
In fact, yes, we have stated in affidavit. No, not on this particular case. We have mentioned that part.
Mister,
But it is
that
there.
we will consider in another case.
Yes, madam.
My question is out here, you, I
2000
won't
and 2003.
let anybody say anything which is not a part of the. But the problem lies here. The works were completed in 2022. 2002, why have you approached this court in 2025?
Your lordship, because we are regularly approaching the respondent
No,
authority.
no,
And in
you are-
fact, in
That
2000,
cannot be a ground. There are many judgments to that effect.
lordship, but there is one particular thing, your lordship, in 2023, in fact, the chief engineer himself directed that the demand proposal be made. So we are under the anticipation that our bills will be released, your lordship. That is why there has been some delay in our.
After 22 years, if you get a demand proposal, then there is something hanky-panky. You do one thing, take all the benefits out there, go to before the civil court. I'm not going to entertain this type of petition. I will say that they say it to be fake, which, and as such, this court cannot consider. Go before the civil court. This court have been very particular on this. I don't even issue notice in a writ petition wherein the amount is claimed prior to 2020. And you are asking me to adjudicate a matter of 2022 filed in 2025. My goodness. Even Tamser Ali would not help you out. Wherein also there is specific statements, opinions being given by the full bench to the effect that it is only in the case of these 3 years, isn't it?
Lordship, it is there. Next to the
That is
petition.
true. Lordship, I may be, liberty may be given to that.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi, the learned petitioner and advocate general, appears on behalf of the respondent numbers.
All the respondents.
All the respondents.
respondents.
The present petition has been filed by the petitioner seeking a direction upon the respondent authorities to pay the outstanding dues in respect of the 8 works which the petitioner claims to have completed. In the year 2002 and 2003. The details of the works, work orders, particulars of the works, as well as the value and the work completion date have been provided at paragraph number 3 to the writ petition. in the form of a table which is reproduced here in under. It is the case of the petitioner that after completion certificates have been issued, the petitioner had been pursuing with the respondent authorities, and the respondent authorities, and it was only in the year 2023 that the chief engineer, which was his document,
Page 83, Annexure 9, Your Lordship.
the chief engineer Roads PWD have asked the executive engineer PWD to submit a demand proposal against the said works for onward necessary action. The learned counsel, appearing on behalf of the petitioner, further submitted that even the Deputy Secretary to the Government of Assam Public Works Department have also written a letter to the Chief Engineer PWD Roads on the basis of a petition representation submitted by the petitioner in connection with non-submission of the demand proposal against the pending payment and requesting the Chief Engineer PWD R Assam to examine the matter and take necessary action. The legal counsel for the petitioner therefore submitted that as then thereafter also no action has been taken, the petitioner have been compelled to approach this court. The record revealed that the respondents have filed their affidavit in opposition, wherein it is categorically mentioned at paragraph number 4 that even after repeated instruction, the petitioner have failed to submit the original copies of 8 bills, completion certificate, original agreement, PWO, formal work order, photographs, inspection report of the concerned superintending engineer, etc., for the submission as is required for the demand submission proposal. It is further mentioned that at paragraph number 6 that the completion certificates which have been enclosed by the petitioner appears to be fake and fabricated, because the completion certificate, as per their requirement at that relevant point of time, was only signed by the executive engineer and not by the accounts officer. In that regard, a genuine completion certificate which was prevalent at that completion certificate, a performer of a completion certificate which was used to be issued at that relevant point of time, have been enclosed as Annexure A to the affidavit. This court have duly taken note of that the petitioner has approached this court against dues which were payable sometime in the year 2002 and 2003, which against alleged dues which were payable in the year 2002 and 2003 against the 8 works, the details of which have been provided in the table herein above. The respondents have also categorically mentioned in the affidavit, filed affidavit more particularly at paragraph number 4, that it is difficult on the part of them to even proceed for submitting for submission of a demand proposal in view of non-availability of the various documents. In addition to that, the respondents have also questioned the completion certificates which have been issued by the which have been claimed to be the completion as submitted, have also questioned the completion certificates which have been enclosed by the petitioner. Considering that The petitioner has approached this court after a long hiatus of 22 years, comma. It is the opinion of this court that this is not a fit case wherein this court should exercise the writ jurisdiction, inasmuch as the defense, a defense which is, it is not, it is the opinion of this court that it would not be equitable on the part of the court to exercise the jurisdiction of under Article 2 to 6 of the Constitution, inasmuch as the respondents herein would be prejudiced on account of the delay of the petitioner in approaching this court, would be prejudiced, have already been prejudiced, now would be prejudiced if directions are passed, inasmuch as there has been a delay on the part of the petitioner to approach this court. In addition to that, it is also relevant to observe that the respondents disputes the very completion certificate on the basis of which the petitioner seeks to make the claim. Considering the above, this court therefore is not inclined to entertain the writ petition, for which the writ petition stands dismissed. Before parting with the record, this court, however, observed that the dismissal of the instant writ petition shall not preclude or prejudice the petitioner to approach the competent court of civil jurisdiction if so advised. Further to that, the period during which the instant proceedings were pending, that is, with effect from 17 to 2025 till date, be excluded while computing the period of limitation.
Highly obvious.
We will be at liberty to issue the limitation part, my lord, in the civil code. We will be at liberty to issue the age of limitation before the civil code, because 2002.
That is already.
That you can very well. I'm only excluding
No, my lord,
this portion.
by referring to this order, my lord, he may, my lord, claim that his case now be entertained because there is a liberty given by the honorable court.
Your lordship has only excluded that
I've
period of
only
the high court.
excluded that portion.
Yes.
I to have granted the liberty if so permissible under law.
Last.
Highly obvious.
তুমি কি দিছে এমএসসি কিয় দিছো হ্যাঁ কি কথা আছে মোৰ পাঠক কেইটামান আছে না হ'ব দিয়ক 2000 এমএসসি appeal চলো এমএসসি appeal. Yes, who is appealing for MSc appeal? Question that arises in this case, whether a gratuitous passenger in a vehicle involved in an accident is entitled to compensation. Insurance policy is an act of service.
Lordship, for 28-29, my senior is on the way.
Who?
GN Saiwala, sir. GN Saiwala, sir.
Huh?
GN Saiwala, sir.
He pays for national insurance.
No. Your Lordship, just give me 2 minutes. I will just call him.
Who?
We are for 28. We are
No, for the claimant.
29. Yeah.
There's nobody for the appellant. We put your name as for the claimant respondent. Okay. None appears on behalf of the appellants when the appeal has been taken up. Ms. So-and-so appears on behalf of the respondent. It is also seen that on the earlier occasions also when the present appeal was called, the appellant was not represented. Accordingly, the instant appeal stands dismissed for non-prosecution. The registry shall return the LCR after after 90 days of the present order. কি এবোৰ? কেইটা দিছো এইবোৰ? মোক কি MSc, CMSc এইবোৰ দিয়ে নেকি? What is wrong? Yes, what is your case?
May it please your lordship. Your lordship, the main ground in this matter is that the exhibit 3, which was the which was the identity card for physically handicapped person, and it was issued by the district social welfare officer, and it showed that the nature of the disability of the injured was orthopedic 60%, but the problem is that
Supreme Court civil appeal direction মতে এইবিলাক দিয়া আছে।
your lordship, the document was not proved by examining any
What?
witnesses.
Which document?
The exhibit 3, your lordship.
Did you put a question? Did you object to that?
In the tribunal.
Yes. Don't come up with that. So record to you. Let me see now. Wait. Which is exhibit 3?
Yes, your lordship.
Let's see. We need to finish off this matter by in 10 minutes. The judgment has to be done and dusted by 10 minutes. Let's see what is this exhibit 3?
Your lordship, it is the identity card for physically handicapped person.
Are you seeing this? He has lost one leg.
That is not the case, I think, your lordship.
What is this?
Some
What
bone
record
fractures
is
were there.
sending you the case report of so and so. এবোৰ কি ফটো ষ্টেট কৰে যে এইবোৰ কাৰণটো কি অৰিজিনেল ৰেকৰ্ড নপঠিয়ে নি Nobody can understand head and tail of this. Read the cross-examination of the petitioner, of the claimant.
Your
Did you
lordship,
adduce evidence?
Yes, your lordship.
What did you adduce?
Cross-examination, because there was no witness examined.
What witness? The witness was there. Evidence of the Narayan
claimant.
Nandi is there,
Yes,
PW1. That
But
I am the claimant of the, I was standing on the road of near the so-and-so, all of a sudden a truck bearing hit me, and as a result I sustained grievous injury. In the said accident, I sustained multiple injury. That immediately after the accident, I was evacuated to so-and-so, that till date I am continuing my treatment, that I had spent 1 lakh for my treatment and at least 1 lakh to go to Patna for better, that as a result of the accident, I became physically handicapped, which is assessed as so-and-so, that I was a driver in profession and earned 4,000 rupees per month, so-and-so. After the accident, I have become physically handicapped due to damage of both of my legs and now I am unable to drive my yard, that I demand Iman as complete, including the loss of order Iman. And how much was the amount given?
Full, your lordship, was
There's an identity card issued by the government of Assam for physically handicapped persons, proved in original. Then
that is the only contention, your lordship.
it is proved in original. You should have put a question there. Nothing remains. Nobody can understand head or tail of what has been written in cross. Do you understand?
No, your lordship.
Read it. You may be good in reading this, something which is absolutely illegible. Read it. If any case you can make out is from this document, nothing more than that.
No, your lordship. I
And
think
or
it's-
give it to Mr. D. Chakraborty. Mr. Chakraborty, read this. Can you read anywhere this anything?
My lord, 2 of my buses have already gone by, my lord. This is an alien bus.
Huh?
2 of my buses have already gone by. This is an alien bus, so I don't know whether I'll hit something or not on the way. Oh my God. This is Urdu.
Urdu, somebody has written something nobody can understand. Nobody can understand it. Now, first of all, these judges should be said. Somebody else is going to read it. Huh? Now let us see how he has done it. The evidence of PW claimant injured while he was standing on the so and so and suddenly hit him, causing grievous injury to the person. He was sustained multiple fractures. The accident took place at Lalmati and the year during his crossing. The accident was not found. Denied by response number 3. In report exhibit 1 shows that a said truck was involved in the accident. 83 so and so, so and so. Claimant is shown is exhibit as the person injured in the year. The oral evidence of injured player read with the exhibit 1 makes it believable that exhibit took place as a causing the issue. In view of the discussion, we found that he has sustained injury. Injured is entitled to compensation in view of the decision in the exhibit 1 shows that the injured was shifted to rear. The exhibit 4 shows that the injured was admitted at the imminent discharge and so and so. Exhibit 5 shows the injured sustained bone fracture. Exhibit 3 is the identity card for physically handicapped persons here showing that the nature of disability of the injured is orthopedic 60%. The injured was operated upon in GMC, then external fixation was done. He was a driver by profession and his salary. His salary is not proved. So his salary is presumed to be rupees 3,000 per month. And we know from our common knowledge that the earning of a driver goes up by daily allowances only, which he actually earns. Daily allowance is not included in the salary for the purpose of computation of year. His is 48, 3,24,000. Has produced exhibited some documents from America. The amount is rounded up to he is entitled to the amount of so and so, entitled to his 10,000 towards expenses of diet and nutrition and so and so. Nothing is there. Chalo. 5 minutes now, the judgment.
Okay,
Heard Mr. So and so, the learned counsel appearing on behalf of the petitioner. Appellant. This is an appeal filed under Section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 13/2/2007, passed in MAC case number 329 of 2006 by the learned member Motor Accidents Claims Tribunal, Kamrup. The brief facts which led to the filing of the instant appeal are: that on 28/1/2004 at around 3:20 a.m., the claimant, Sri Narayan Nandi, while standing on the side of the road near his vehicle, bracket mini truck, at Lalmati on NH 37, a truck bearing registration number AS01C 7335 coming from the opposite direction, driven in a rash and a negligent manner, hit the claimant. Resultantly, the claimant sustained grievous injuries on his both legs and immediately shifted to the GMCH for his treatment. The claimant stayed in the GMCH from 28/1/2004 to 10/4/2004. The claimant thereupon was again admitted in the GMCH from 9/6/2004 to 21/6/2024 for treatment. His operation was done in the GMCH and external fixation was done on his left leg. Thereupon, the claimant was also issued a certificate, an identity card for physically handicapped persons by the district social welfare officer, showing the nature of disability of the claimant to the extent to be 60% orthopedic. It is also seen that the claimant thereupon approached the claims tribunal by filing a claim petition. On 15th of March 2004, the said claim petition was how is it possible? You have filed a claim petition. Filed a claim petition for the member Motor Accidents Claims Tribunal at Gauhati, which was registered and numbered as MAC case number 830/04 and subsequently renumbered as MAC case number 329/06. In the same claim petition, the claimant claimed an amount of rupees 3,50,000 as compensation. The appellant, who was the respondent number 3, have filed a written statement taking the usual defense. On the basis of the pleadings, the learned tribunal framed 3 issues which, being relevant, are reproduced hereinunder. On behalf of the claimant, he adduced evidence along with all the documents along with and exhibited various documents including the physically handicapped certificate, bracket exhibit 2, identity card issued by the government of Assam for physically handicapped persons, proved in original, exhibit 3, discharge certificate of the GMC 8, exhibit 4, medical certificate, exhibit 5, as well as various prescriptions, bills, vouchers, X-ray plates, photographs, etc. The appellant, however, did not adduce any evidence. The learned tribunal by the impugned judgment and award while deciding the issue number 1, came to a categorical opinion that on 28/1/2004 at about 3:20 a.m. at Lalmati under Khetri PS. The vehicle number AS01/C7335 met with an accident due to rash and negligent driving of the vehicle. While deciding the said issue, the learned tribunal also came to a categorical opinion, also reached an opinion that the claimant suffered injuries on account of the said accident. While deciding the issue number 3, the learned tribunal took in note of the various exhibits, including the certificates which were issued, and more particularly Exhibit 3, which is the identity card of the physically handicapped persons issued by the district social welfare officer, showing the nature of the disability of the injured is orthopedic 60%. And on the basis of the above, came to a finding that the claimant was entitled to an amount of rupees 3,24,000 on account of compensation. Full stop. In addition to that, the learned tribunal also held that rupees 67,559 the claimant was entitled on account of medical treatment. In addition to that, the claimant was also entitled to rupees 10,000 towards expenses of diet and nutrition and rupees 4,400 as transportation during the period of the treatment. Accordingly, the learned tribunal came to a finding that the claimant was entitled to rupees 4,06,000. The learned tribunal also observed in the impugn award that the insurance policy was valid, and therefore the appellant was directed to make the payment within 60 days. Along with interest at the rate of 6% from the date of filing of the case till payment. The records reveal that pursuant thereto, the present appeal was filed. In the year 2008, the only ground on which the present proceedings have been the appellant have challenged the impugn award is that the learned tribunal ought not to have taken into consideration the Exhibit 2 and Exhibit 3 without having been proved in accordance with law. This court duly takes note of that the Exhibit 2 is the certificate of is the physically handicapped certificate, and the Exhibit 3 is the identity card issued by the government of Assam for physically handicapped persons. during the cross-examination of the petitioner, of the claimant, the respondents had, the appellant, who is the respondent number 3 in the said proceedings, did not challenge the exhibit 2 or exhibit 3, wherein it is wherein it is certified that the claimant had total disability of 60%. Taking into account there being no challenge to the exhibit 2 and 3 during the cross-examination, it is the opinion of this court that the learned tribunal was justified in accepting the exhibit 2 and exhibit 3 in view of the well-settled principles of law as laid down by the Supreme Court in the case of so-and-so versus so-and-so, reported in 2003, 7 SCC, page 858 or 350? Which one?
Your Lordship, I have no.
2003, 7 SCC, 350 तसे सब. The judgment that আছে 350 होगा लगे. Yes, I think so. इतो राजस्थान हाउसिंग है बोली कोई प्ले तार दिसे इतो, हाँ. Under such circumstances, this court does not find any infirmity in the impugned judgment and award dated so-and-so, passed in MSC case number so-and-so. Accordingly, the writ petition appeal stands dismissed. You have deposited, did you get a stay? No stay.
Yes, Your Lordship.
Huh?
Stay, we have filed a MISC, but whether it was stayed.
Yes, any substance. Yes. No stay. That is why. No stay. It is observed and directed that in the circumstance the appellant have not yet deposited the said amount, the same be deposited along with the applicable interest as per the judgment and award dated so-and-so from the date of filing of the claim proceedings. The said deposit be made within a period of 6 weeks from today.
Your Lordship, only one.
Then the
thing.
LCR.
The statutory amount may be refunded.
What?
Statutory amount of 25,000.
The statutory amount of rupees 25,000, which was deposited at the time of filing of the appeal, be returned upon proof submitted before the registry that the entire awarded sum have been deposited before the learned tribunal.
What's up?
And oblique paid to the petition.
I'll satisfy regarding the query, Your Lordship, but before that, I have instruction to withdraw the matter, Your Lordship. And regarding the completion certificate, it was issued after the tender process, Your Lordship. The completion certificate was issued after the tender process, Your Lordship.
You want to withdraw?
Yes, Your Lordship.
Mr. P.K. Sharma, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the writ petition. Mr. So-and-so appears on behalf of the NHF.
Maharaj, I'm appearing for TCIL.
Mr. So-and-so appears on behalf of the TCIL. Taking into account the above, the instant writ petition stands closed on withdrawal. In 10 orders, if any, stands vacated.
Grateful.
May I please? Yes. My lord, this is the batch of cases your lordships issued rule in in two of those cases, all connected matters and relating to those quarries in Kaziranga area. And your lordship has fixed the matter, although affidavits.
Now you're running?
No, no, my lord, the story is very difficult. My lord, we were given the we were earlier, my lord, there are two things. First phase ended in a litigation before the Supreme Court, and that proceeding was closed. My lord, what I will do, which is that order? I'll place your lordship's order itself, because in two of the cases I moved the application and your lordship passed the order. So the substance of the situation was very secondly put by your lordships. I'll just place this as a preface. This is your lordship's order, Tularam Terang, na? I just place this case so that I don't have to trouble your lordship with all the facts again. Item 16. Supreme Court of 12/4/19, 19, 4/19. No, affidavit is there, no? You want to see? Huh? Which 13. Item 15 to the point. More request I see. Petition. Petition. So, Mr. Goswami, there is a order passed in 2019 by the Supreme Court. Correct.
And in that order of 2019, as well as in the year 2024, they have categorically mentioned to the effect that whatever needful is required to be done, we have done. Everything is shut down. Thereupon, in 2025, on 29/1/2025, a letter has been issued. After that also, you were allowed to run. All of a sudden, it is being stopped. That is why you have approached.
Absolutely. Absolutely.
Now, they say that it was done on the last occasion when the council who represented the forests, they say that it was done on the basis of the CEC's complaint.
Correct.
We have stated that the CEC's jurisdiction is only limited to placing the necessary materials before the Supreme Court if there is any violation to the orders passed in that governance matter. Now, has the CEC thereupon taken it up before the Supreme Court? I'm told that the Gauhati and Godawaran matter has been closed by the Supreme Court.
I am not sure, Milord. Has it? I don't know. Because it has been going on from 95 onwards.
Yeah, that is what. But that day somebody was telling us that the Gauhati and Godawaran matter had been closed.
Oh.
But I don't know that.
I have.
Anyway, so therefore the question is, can they continue to, because you are doing it earlier, they were in a particular place. You shifted them from there to another place.
Correct.
Into the Borjuli area, no?
In these two cases, Borjuri area, the other is Nopam, and then the another is.
But this is different from the Parkup.
Parkup is the range,
Okay,
but
Parkup Pahar. Okay. You were originally allotted in a contract shifted to Borjuri PP land under northwestern range Parkup Pahar.
Correct.
So now you are in the Parkup Pahar.
Correct. Range is that.
Now their basic area is, although it does not fall within the 10-kilometer eco-sensitive zone, it is there also stand that it is outside the 10 kilometers.
Right.
But some rivulets or something which originates from Karbi Anglong is on the way. That seems to be their stand.
That is only in those two cases, so far as that river thing is concerned. Rest of it, The rest of it is not with regard to that.
Okay.
But the basic difference is this, my lord. The Supreme Court was dealing with what they said in their order, illegal mining, illegal unauthorized mining. And they said that this is illegal, you close this. Then the state closed all those about 40, 50, 33 and plus something units and filed an affidavit, and then, my lord, November 24, Supreme Court closed the proceedings saying that our order has been implemented. Now, our present set of cases start thereafter. It's a new phase. Now, here, my lord, starting from the very initial phase, all the required permissions are obtained. It is not illegal mining. The whole problem is that confusion still persists in the hands of the CEC and then percolates to the others, because CEC is really passing the orders. Do this, close this, and they're, without applying their mind, they are just closing. So the CECs is not appearing before your lordships, but that is the order and direction to all the authorities, and they have blindfolded carried out all this. That is the whole problem. But the difference between this and the earlier 2019, which ended in 2014 to 24, the proceeding that related to illegal mining. Now, so far as this is concerned, I'll just place some of these pages below. Your lordship will find that all necessary permissions were obtained. If your lordships, I have prepared from a case below, which is now 15. I'm very sorry to trouble your lordship, but this may not be that matter. So if your lordships don't mind, your lordships can take, it's all same, but I have prepared the case. Item 15. Kodam Terampi. Kodam Terampi too. Yes. The Kodam Terampi, writ petition 5203 of 2005. If your lordship's first letter, if your lordships take up at page 201, my lord, this is dated 30/12/19.
Zero one?
201, my lord. We have filed an additional affidavit incorporating this letter. This was inadvertently not put earlier.
It is in WPC number 5203.
Absolutely, yes. At Miller page, it will
There
be
is no additional affidavit here.
197, it starts.
197 is the affidavit in opposition filed by the respondent, number 16. And then there is an affidavit in reply filed on 6th of August by the
Miller,
petitioner.
Additional affidavit, as per my brief, it is starting at 197 to 200.
But that is not here. It has not come till now, I said. Because otherwise the pagination, more particularly Kadam Terangpi, WPC number 5203/2025.
Oh, sir, said
Because obviously it must have been filed, because this is an affidavit in reply filed on 6th of August. That has also come on record. Well, affidavit must have been filed much prior to that if it is so. Because their affidavit which was filed by the respondent is of 28th of July 2026.
Well, let us ignore this for a moment, Milord. I'll go with the main writ petition, starting with the letters, Milord, which your lordships will find at page 42, 44. Well, if your lordships kindly turn, Milord, to page 42.
Yes.
This is a letter coming from the Director of Geology and Mining to the Divisional Forest Officer. Approving, Milord, the mining plan, which was sent by the DFO earlier. Approval of mining plan along with progressive mine closure plan in respect of Nopani, Monsa, Ingti, number 1 Stone MC area. This is the new area, Milord, where it was relocated in Karbi Anglong district, Assam, submitted under Rule 51 and 52 of the Mineral Concession Rules 2013. And Director is replying to the earlier letter of 8/2/2001, whereby the Divisional Forest Officer
I think the impugn actions is based upon Annexure 3 to the affidavit filed by the respondents, page 218, whatever page it may be in yours. Because it seems that after the CEC's directions,
Yes.
there is a meeting held,
Yes.
and in the meeting they have banned everything.
Everything. Because the original direction is coming from the CEC. And all these officers, starting with the chief main officer of state of Assam, he is writing to the principal secretary, and then he is forwarding it to the district council, and district council is implementing. So the whole problem is the CEC is making a confusion between the first order of the Supreme Court, which, as your lordship has seen, related to illegal mining, and the present set of cases are to a different relocated area, and where all the requirements are complied with.
Where is the CEC's directions? Anybody has the directions? No.
Yes.
We have
that is
annexed in
the
our affidavit also.
impugn orders.
Yes, but page 17.
Our 219.
Where?
In our affidavit, my lord, it is page 219.
In
That
219.
is direction in the March
In that petition.
in the affidavit opposition, my lord.
These are CCs. Please
CC,
refer
my
to the letter dated so and so. And to the man participated in the meeting was observed that the issue has not been addressed. But this is sometime in the year 2026.
That is the last order, my lord. The initial order, my lord, we have annexed in the first affidavit, my lord, in the Jiten Ninja case, item number 13, my lord. In that first order was 30 May 2025. That is in the first case, read petition 6479 2025.
Mining and all going on in some way. 35, 2025 is where?
It is, my lord, page 147, annexer 6 in the read petition number 6479 2025. First order, G10 Ingzai.
Page 1.
13, page 147. They are interpreting the order dated 12/4/2019 Supreme Court's order. Concluding part as page 156, 156.
কোনটো ভাল দিয়কচোন। তেনেহলে আমালৈ একটু কপি দিয়ে আমি
You also join that in the document? Okay.
Now, what has happened? This report, has the CEC placed it before the Supreme Court?
No, no.
CEC has not placed it Supreme Court. CEC issued the direction to the Chief Secretary to the Government of Assam. Accordingly, minutes were there, and the Special Chief Secretary of Forest Department directed us to close the mining. Last, my lord, in the order dated 5
Where is the direction in out here?
that is in the, my lord, in our
In that page,
my lord, minutes of the
conclusion
is there,
the Supreme Court, page 156.
156, my lord.
So,
So, my lord, they are
so
interpreting
all
the
kinds
class
of
A, my lord.
mining and related activities along the aforesaid Kaziranga National Park area.
And in the catchment
Entire
area, my lord.
catchment areas of so-and-so originating in the Karbi Anglong Hills and flowing into Kaziranga National Park, including tiger reserves, are restrained.
So, my lord, they are
Director
interpreting the
General
catchment
Forest
area.
The Chief Secretary shall ensure. That's okay, but have you identified that these are the persons where it has been done?
In the 2019, my lord, that catchment area, my lord, subsequently, my lord, when the CEC passed the order in 2026 that we should not suspend it, we should cancel it. Then we have issued it, my lord, asked to, my lord, verify the what is the catchment. It is a broad area, my lord, and there is no definition of entire catchment area. What is the entire catchment area which is flowing river to the, my lord, river relates flowing to Brahmaputra, my lord? Do we have wrote to the IIT Roorkee, my lord, and that they have already submitted a report, my lord, that we have not bring it on record, my lord. That is the.
But why haven't you approached the Supreme Court by filing an IA to make it clear?
My
The Supreme Court would do, they are the authors of this direction, so they will be the best one to answer to that.
My lord,
because what they are saying out here, very well, I understand for you to identify which will be the catchment area.
My lord.
Whether it will be only the area where the water has started.
My
or
lord.
till which
Or
period?
coming to
Because,
the, my lord,
if you go to a very, unless it is the entire catchment area will include
Yes.
what? And
There
what
is
is the area means how much otherwise would be the entire area?
My lord, if the entire catchment area is there, everything in the Karbi Anglong, if you are taking the whole Karbi Anglong area, entire catchment, everything is coming from that particular hill area to the, my lord, to the valley, my lord, to the area, my lord. So we have already, my lord, entrusted, my lord, to study about the catchment area to the and IIT Roorkee, my lord, has already submitted a report. We have not bring it on record, but before that, my lord, all the mining permits has already been cancelled by the Director of Geology Mining at this stage. All the mining permit.
You have to understand that the judgments of the Supreme Court or the High Court cannot be taken as an elusive theorem. So therefore, the understanding has to be on the basis of what the court meant.
My lord.
So what is meant by the entire catchment area? Would it include or encompass the entire area from the river starting till the river ends? Or flows to the Kaziranga?
Kaziranga.
Or is it all rivers which starts from Karbi Anglong or any other place and goes through the Kaziranga? Because then in that case, it may also include the Brahmaputra.
My lord. That is the point, my lord.
So
So the sea
also, because the Brahmaputra also flows from,
yes, my lord.
comes from China and then it goes away out here through Kaziranga and goes to it. So entire mining operations which are there on the banks of the Brahmaputra from there to Bangladesh will be closed.
So, my lord, as the CEC, my lord, interpreted that area until and unless drainage system and catchment area we could not identify. So they asked to suspend first, then they asked us to cancel the mining permit. And accordingly, my lord, Director of Geology Mining has already cancelled the mining permit.
Of them?
My lord, all mining plan, my lord. That has already, we have annexed it, my lord, in our affidavit. It has already been cancelled mining permit by the Director of Geology Mining. So now the.
Has it now been challenged?
No, that has not been challenged. We have annexed in our affidavit, my lord. That is, my lord, page 158.
In fact, Goswami, if they have cancelled the mining plan, isn't it required for you to challenge it? We are on a suspension.
Lord, look at page 146. In this affidavit, my lord, page 146.
My lord, this is all going on. Have we received the cancellation?
Page
order?
140 of which one?
146, my lord, WPC 6479.
146.
146.
With reference to, no, this is written to the PCCF.
PCCF, my lord.
But where is the cancellation?
Second paragraph. All the mining plans, if issued from this department, will be treated as cancelled in the above mentioned areas.
But whatever may be, don't you think that it is the petitioners who have to be informed?
All mining.
All mining.
Understood.
My lord.
There is some right flowing to the petitioner.
My lord. My lord, advocates are there, my lord. They are representing Director of Geology Mining is there, my lord. Advocates are there. They can
my lord,
explain
the
it.
suspension order was revoked thereafter, and then we were again allowed.
On 885, the order was revoked pursuant to an order of the High Court. Thereafter, on 14.5, we were allowed to continue. This letter, which my senior is showing, is a letter dated 25/4/2025. On 8/5/25, our suspension were revoked and we gave the royalty and we were allowed to continue. No, that is one thing. But Mr. Sute, don't you think there is a requirement of issuance of a specific order for each petitioner?
My lord, Director.
You are asking, the Director Geology is asking the PCCF to do so.
My lord.
But asking
My
him
lord,
to
not
do
doing
so,
so, my
does
lord.
it mean that it is
Not doing
cancelled?
so, my lord. All the mining plan, if issued from this directorate, will be treated as cancelled.
Understood. But my question is, have you informed the petitioners?
My lord, Director of Geology Mining and say, my lord, I'm not.
So therefore, without that information being given to the petitioner, there is no cancellation.
My lord, we have annexed in our affidavit. We have we have brought into the notice of the court, my lord, on 29/1/2026 by filing the affidavit. And the Director of Geology Mining cancelled this, my lord, permit, my lord, at this stage. And two parts is there, my lord, at this moment. My lord, the draft notification, which is earlier, it is, my lord, another way, it is, my lord, now 10 kilometers. That has all been recorded on the submission of the Forest Department. If the, my lord, eco-sensitive zone is 10 kilometers and the mining of the particular mining is within the 10 kilometer, whether at this stage, my lord, that can be allowed to operate after, my lord, validity period is over.
So how many rivers are flowing from Kaziranga, from Karbi Anglong?
My lord, at this moment, my lord, that report is not with me, my lord. I can bring it on record by way of affidavit, my lord. The report, my lord, which has been vetted by the, my lord, IIT Roorkee, my lord.
No, understood, but how many? Because here the direction is originating in Karbi Anglong Hill Range.
My lord.
Means it has to originate only from Karbi Anglong Hill Range.
Yes,
if it is beyond that, it cannot.
My lord.
So those which come like Dhiko and all would not come with it.
Originating.
So it has to start from Karbi Anglong, not others.
Oh, my lord. So only interpreting.
Your
My lord,
lordship,
my lord, if we interpreting originating, my lord, so my lord.
No, if you are interpreting the entire catchment area, it will include everything. Means those just nearby, if you
Yes,
go
my lord.
towards,
It could be originated from Karbi Anglong, my lord. That means.
if you go towards this particular,
it must originate in Kaziranga and it must flow to
Originating Karbi Anglong
Karbi Anglong
and
it
must flow to
go
Kaziranga. Kaziranga National Park.
Page 73 for the moment.
of which writ petition?
This Tulirap Serang.
বেলেগ কৈ আছা।
Tulirap Serang item 60.
70.
64, 73 and 74. It clarifies the entire.
Everything in a state of confusion. It is Tularam Terang, 5402 of 25. In fact, my lord has issued notice on this also, on 15/9/25. My lord, kindly turn to first page 63. 63, no, honey. 64. 64, I'm sorry. This is from the additional chief engineer to the divisional forest officer. Details of rivers originating in Karbi Anglong hill ranges and flowing into the southern boundary and in the entire catchment area of the Kaziranga National Park. That is the heading.
So in pursuance to this order passed by the learned coordinate bench on 5/5/2025, the suspension was revoked.
And thereafter again we not cancelled. We resumed and again it was cancelled.
Yes, Forest, what have you done? What is your rule? No, there, don't, we have a mic there also. Whatever.
These matters, my lord, there is an order passed by Justice Chaudhary that where is the question of EHZ came. The question of EHZ came, EHZ, eco-sensitive zone. So our part is very clear that if there is no proposal, it stands today as on 10 kilometers. And there was a report called by the our authorities that these mining areas fall within that beyond 10. So we don't have any access control. That apart, my lords.
Are you not appearing for the director of geology?
I don't appear for that.
Who appears?
Government appears.
What is your stand on this? Because the Directorate of Geology have issued this communication.
In fact, my lord, there is only, nobody has filed affidavits because DFO, Karbi Anglong has filed only affidavit. And the state's version, your lordship is not having on affidavit.
No, my question is, everybody, Mr. You see, Mr. Chutia, the court had, the CEC is heavily against you. If you see the report, they are not against anybody else. A complaint was filed by somebody, an anonymous, saying that you are permitting it. This is the allegation.
Yes, madam. Yes.
And therefore, there was a specific direction to you to follow what has been stated by the Supreme Court.
In 2019.
In the 2019. It does not say that you remove this or that.
My lord. My lord.
Because if you see that, therefore, my specific question to you was, what was the conclusion? The conclusion out here, if we see from this affidavit which has been brought in on 35, kindly see, it doesn't say anything. The Supreme Court has so and so. The state government shall ensure. The Chief Secretary so and so shall ensure that these orders of the Honorable Supreme Court are complied with.
My lord.
The Honorable High Court of Gauhati shall be apprised of this order of the Honorable Supreme Court by KAC as well as the Forest Department by filing suitable petition requesting the Honorable to review its order dated 5/5/2025 in view of the directions passed by the Supreme Court.
My lord.
So therefore, have you or anybody filed that type of petition?
My lord, in that, my lord, 5/5/2025.
That is the order by which the revocation has been
My lord,
suspended.
no, my, that, by that order, my lord, they were allowed to, my lord, extracted stone, my lord.
No, 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 no. No, no, 5/5/2025 order
My lord,
is categorical to the effect that, look here, the suspension which has been made was illegal and therefore 7 days time was granted to you to revoke the suspension.
my lord.
And in pursuance thereto on 8/5/2025 you have revoked, and this is further followed by another communication on 14/5/2025. So therefore, what is being sought for, directed by you, by the CEC to you or to the government, is to file an application seeking review of that 5/5 order, which you have not done. Okay. The Director General and the concerned police shall ensure that no illegal mining takes place in the aforesaid area and no transportation of illegal mine material takes place from Karbi Anglong Hills.
Right.
Illegally mining. Illegal mining and illegally mined materials.
My lord.
The illegality will be qua the area pertaining to the mining and related along the Kaziranga National Park area and in the entire catchment area of so and so. You are yet to find out what is the entire catchment
My
area.
lord.
Neither you have asked the CEC what do you mean by catchment area. You have not.
That order is from the Supreme Court, my lord. So requirement
Understood. So,
interpretation of that area, my
you see,
lord.
the problem lies because of the ambiguity.
My lord, yes, my lord.
You are faced with this trouble on account of the ambiguity.
My
The
lord.
CEC either has to clarify to you what do you mean by what the entire catchment area,
My lord.
or you have to approach the Supreme Court.
My lord. So, my lord,
Without approaching the Supreme Court
no,
in this matter,
there-
we can't.
There, my lord, does paragraph 4, my lord, that so drainage, my lord, Karbi Anglong Autonomous Council shall complete and submit a comprehensive watershed drainage analysis report, my lord. So we have to study that report, my lord. Then after that, as we have now received the, my lord, that report, my lord, so we have to submit it to the CEC, my lord. That on that basis, after completion of that, my lord, our, my lord,
That was in
catchment
2025 you have to submit. We are
My
in
lord.
2026 August. No new mining settlement permits shall be issued by Karbi Anglong or any other authority. The Karbi Anglong shall submit quarterly status reports to the CEC through the Chief Secretary detailing the action taken. The Karbi Anglong shall strictly ensure no violation of the environment norms or the mining regulations occurring as expressly assured by the Forest Department during the hearing of so and so.
So look the 5 also, my lord. 5.
Uh.
Page 1 for the 5. No new mining settlement, lease or permit shall be issued by the Karbi Anglong Autonomous Council or any other authority in the areas draining into Kaziranga National Park and Tiger Reserve until the watershed boundaries and areas of the concern have been scientifically delineated and verified. So, my lord, that we have entrusted the work, my lord. We have received the report. So we have to approach the CEC along with this, my lord, our report, my lord. And we are we can place it before this honorable court also by way of, my lord, additional affidavit, my lord. That report, my lord. Where by then, my lord, it can be easy to whether that report, my lord, it tallies with the mining permit of the petitioner. I have not yet looked into it also. I have not received it, my lord. So
Now,
that
tell me,
in the affidavit
no,
we have
I understand everything, but the thing is, what is the direction being given? What is the power of the CEC to
My
do
lord,
that?
PSA wrote, my lord, to the registry, my lord. That is in the case number, my lord, 5220/2025.
What did they write?
My lord, CSA wrote to the registrar, my lord.
5220.
5220, my lord. Item 14. That's CSA's letter is in the file, my lord, I think.
Letter is marked as X. The letter is marked as X.
Your lordship,
5220 to the option.
your lordship, it will be of interest if your lordship read it.
No, the direction.
No, I am
the problem
surprised
lies
the way
is-
things are.
You see, not only a constitutional court is looking into it. There is a Supreme Court who has to look into it. Now, can the CAC pass these directions?
No, no, their notification is on record. They can't do that.
CC letters. Restart legal city.
Okay, Goswami, let's read the order of the Supreme Court dated that order by which that order was passed.
12/4/19.
19. And if we see that interlocutory application number 42944 considered the report number 6 of 2019 with respect to illegal mining in Kaziranga National Park. We have asked for the response of the state of Assam. Learned counsel appearing for has prayed for 3 weeks' time. Response be filed on or before so and so.
Yes.
In the meanwhile, as certain matters are urgent as apparent from the report, following aspects are mentioned in the report number 6 of Iman. Number 4, ban forthwith all types of mining and related activities along the southern boundary of the KNP and in the entire catchment area of the river streams and rivulets originating in Karbi Anglong Hills and flowing into Kaziranga National Park. In view of the aforesaid, we order that all kinds of mining related activities along with so and so are restrained. No new construction shall be permitted on private lands which form part of the 9 identified illegal corridors. So therefore, this was passed in 2019.
12/4/2019.
So it is required for you to seek a clarification from the Supreme Court.
Well, it's
What do you
subsequently-
mean by that? But
subsequently-
my question is, can the CC has the power to oversee,
Hello.
but can the CC pass orders? My question is that.
Hello.
Wouldn't it be exercising a jurisdiction beyond its competence?
Hello. CC represented by the central
If
government.
there
council.
is a violation, it is for the CC to report it back to the Supreme Court, and the Supreme Court will pass appropriate directions.
My lord. That is the my lord. That
But
is the procedure.
how can the CAC direct this aspect at Roman 5 and Romans 4 and Roman 5?
My lord. My lord, CEC represented by the Central Government Council, they have received a notice on behalf of the CEC also, my lord. And they are the best person to address on that particular point, my lord. What is the power of CEC, my lord? How does CEC require to function after the new gazette
CEC
notification?
has been formed on the basis of a particular.
Act, my lord, under the environment protection.
No, let us see that environment protection.
My lord says, my lord is very correct. If my lord recalls the John Kennedy judgment, my lords,
Ah.
in that, my lord, CEC reported back everything to Supreme Court, then Supreme Court gave it.
Yeah, this is how it is done. Because the CEC, if you write see the first John Kennedy's order,
Yes.
whereby you see John Kennedy's case is another a special case where these persons were already there,
My lords.
and thereupon there is a declaration of to become a reserve forest. Then the Supreme Court, there was a direction which matter went to it was there in the Madras High Court, and then it went to the Supreme Court. Now in the Supreme Court says that Madras High Court did not take into one consideration, so therefore we take up as to how these persons can be evicted. So therefore the CEC was directed to look into it and make suggestions to that effect. The CEC make those suggestions, and therefore you see the follow-up order on the basis of the CEC's observations. My question, however, is can the CEC, in view of that, pass 4 and 5? If the 4 and 5 cannot be passed by the CEC, that needs to be actually placed by the CEC before the authority, before the Supreme Court.
Your Lordship will kindly see the notification itself, Milord, at page 195 of item Kodam Terang P.
Which one?
That is the notification of the CEC.
Bottom ten.
The first item number 15.
Page?
195. 5th September 23.
Okay, that is your, okay, got it, 195. In exercise of the powers under subsection 3, so the central government hereby constitutes a permanent authority to be known as the Central Emban, following empowered on the sphere for the purpose of monitoring and ensuring compliance of the orders of the Supreme Court covering the subject matter of environment, forest and wildlife related issue arising out of the said order, and to suggest measures and recommendations generally to the state as well. Yeah. This is a suggest measures and recommendations. The power is only to make suggest for more effective implementation of the order. So this is suggest measures and mechanism, measures and recommendation. It doesn't have binding effect.
And that will be made clear, Milord, by clause 2.
The power and functions conferred over the committee by the so-and-so to monitor the implementation in the above manner and place reports of non-compliance before the central government for appropriate action. To deal with the application made to it by any aggrieved person and whenever necessary to make a report to the central government in that matter. For the purpose of effective discharge of powers conferred upon the committee under this order, the committee can call for documents, examine and advise or recommend on issues referred to the committee by the central government from time to time. In case any suggestion or recommendation of the RIA not acceptable to the state or RIA, the government shall give reasons in writing for not accepting the same, and such decision of the central government shall be final. In case of the deferment of the decision of the state government, with the recommendation of the Central Empowered Committee, a matter shall be referred to the central government and the decision of the central government shall be final. So from here, what it appears is the recommendations or reports what are to be submitted are to be made to the central government. And if there is, the state government does not listen to it, and here in this case, taking into account the Karbi Anglong Autonomous Council would be a state, So therefore, if you don't agree to it, it has to be reported to the central government.
That is a procedure. But Lordship will look into only the rule 2A, small a, 2A small a, to monitor the implementation of Supreme Court's order.
Understood. There is no quarrel.
In above manner and place.
To monitor the implementation of the Supreme Court's order in the above matter and place reports of non-compliance before the central government.
But
So
here
it
in
has
this
to be
case, my
done
lord,
before the central government.
whether 12/4/2019, whether we are not complying or not complying, my lord, CEC, if the CEC looks into the matter and pass the direction to us, to the state government, and state government pass direction to, directed us to close the mining. Factually, that is the part, my lord.
That is what has happened.
But how can the CEC report to the state government?
It
My
can't.
lord, that we have annexed the letter, my lord, and the my lord, government.
No, as per this, unless this notification have been amended or anything,
My lord.
the state government has no role.
But Special Chief Secretary, Government of Forest Department wrote to us, my lord, there's a minute and directed us to,
All
my lord,
these
close
things
the
are
mining.
understood. But my thing is, how does it is all to be referred to the central government unless the central government has delegated the power to the state government.
My lord, my lord.
And CEC is entertaining an anonymous letter, whereas in clause 2, small b, it is specifically provided to deal with any application made to it by any aggrieved person. An anonymous person can't be an aggrieved person.
Whatever may be, let us
I'm
not go
only-
into that, but all things points out that the CEC has to report to the central government.
Correct. In one of the cases, Supreme Court said that we have created it and it is now trying to sit over us.
My lord.
That judgment is there.
That point can be clarified by the forest department, my lord. That's the, on receipt of that, my lord, direction from the CEC to the chief secretary, my lord. The chief secretary called the meetings and in the minutes, there is a discussion
But
to
the
put
chief
the money.
secretary forest department does
forest-
not
he is-
appear.
he is appearing, my lord.
No, no. Mr.
Nobody is
Teacher,
filing
forest
an affidavit.
department does not appear for chief secretary. Who appears for the chief secretary? Then what is your stand? Tell me how can the
They have not
CEC
filed
report to
affidavit.
you?
That is the problem.
How can the CEC report to you? No, you cannot say the lordship, but you have to come up with something better than that. What? No, the question is, if we see, unless there is any other notification, Mr. Gogoi, there is no any other notification beyond this?
No.
Because this notification does not give the power to report to the state.
No, there's no other note.
The CAC's role is limited to whatever happens to report to the central government. Maybe the central government will direct the state government.
Correct.
That is the only way.
Yes.
But the CAC does not have a role directly with the state. You see, kindly see, this is the most important thing. To monitor the implementation of the Supreme Court's orders in the above matter and place reports of non-compliance before the central government. So therefore, the central government has to take a decision, because I think this must have been done because the central government has the power under the Forest Conservation Act.
My lord, my lord.
That must be the reason why.
But here, my lord, direction was issued, my lord. First direction was issued to the special chief secretary, forest department. That is page 225. First order 23,
No,
2025.
all are understood, but my question is that
My lord,
can the CEC direct to the state
my
government?
lord, my lord, as per the my lord, notification issued
Unless
under the my
there's
lord.
anything else,
Yes, my lord.
who appears for the central government or the CEC?
No, they are not appearing.
No.
CEC is not represented.
But in the letter wrote to the my lord register, they requested the additional solicitor general to represent my lord CEC.
Ah,
That
that
is
is
there.
so. You are not additional solicitor then. You are nobody in that respect.
There's a Bronson Terang case, my lord. That letter you get. 5220-2025.
It has been written to IAT and necessary with respect to the IAT for information to the Iman and Iman. Key position. We do one thing. You ask the Deputy Solicitor General to appear in this matter. One, as to how the CAC will have the jurisdiction to issue the communication dated 35/2025 to the state government or its functionary in view of the notification dated so and so. That is one. And we ask you to bring on record
My lord,
your affidavit
my lord.
by which you say, find out what is this.
Well,
But I think
my lord,
you need
actually,
to
my lord, we have submitted a report to the Supreme Court. Supreme Court closed the, my lord, that particular
understood. So
my lord.
therefore, once it is being closed in
My lord.
2024,
My lord.
there was
Now
no
again
necessity
reopened by the CEC,
unless
not
there
by
is
us, my
something to that effect found. And
My
if there is a violation, obviously the CEC has to report to the
Report
state
to-
government.
My lord.
So therefore, that is one aspect. And the second is you bring on record that because the
My lord,
Supreme Court's
report.
order says originating from Triya,
Karbi Anong Hill
whether there is
region.
any report. Because unless you find that,
My lord.
you see, 5 comes into play. The direction for 5 only comes into play when
The rivers originating from Karbi Anong Hill region. And
no,
flows to the
wherein
Kaziranga
it
National
says
Park.
that don't do anything till you then don't make that assessment which is required under 4.
My lord, my lord.
So this direction which is being given appears to be an exercise of power beyond what is being given in the notification.
My lord.
Let's put a question
Well,
to the central government,
well.
let them answer to that. That is it. And in the meantime, you bring on record
Well.
your. I have heard Mr. P.K. Goswami, the learned senior counsel, assisted by Mr. B.P. Bora, appearing on in this petition's numbers. Give your numbers. And Mr. Parthik.
My lords,
where
I
are
appear
you?
in, I appear in 18 and 19.
You are assisted by whom?
My lords, BP Bora, my lords.
How is it?
No, my lords, he is the common.
It's a mixture, my lord. He is here, he is there.
My lords, one thing I may point out, my lords.
That is the beauty
Yes.
of technology.
Tell me.
My lords, the two impugn orders are based on some other issue, on two totally different aspects. One is, my lords, the first suspension order was on the eco-sensitive zone, whether we fall within it. Then, pursuant to your lordship's order that we filed the review, the second order rejecting the review is also that we didn't have the approval of the National Board of Wildlife. Because your lordship, in paragraph 5 of the Supreme Court's order of 20th November 2024, records that the council has taken all steps to stop illegal mining. Our problem starts from 29th May 2025. So it couldn't have been this illegal mining could not have come to our, because they had already issued notice of closure, suspension. And the orders which were under, the first impugned suspension order or the subsequent order does not make out a case that we are carrying out any illegal mining. The grounds are totally different.
No, Mr. Goswami, the question is, here, as I could see from all these facts,
My lord.
they are not permitting you only on the ground of that communication which was issued by the CEC on 35/2025.
True, my lord, but the impugned orders, whether it's 29th of January 2025 or the subsequent order rejecting the review, the grounds are not illegal mining. The grounds are one, in the first order, that we fall within the eco-sensitive zone. The second order says that you don't have the approval of the National Board of Wildlife. They don't say that we fall within the area where it is impermissible to carry out mining activities under the Supreme Court order or the sea. I'm just pointing out, my lords.
Understood, but that is okay. But now it falls down to because of the directions passed by the CEC.
Yes, yes.
Well, these orders have been passed pursuant to CECs.
No,
because
CEC's order is of 35/2025.
my lord, the subsequent review order is subsequent to that. It's in July. The ground for rejection of review, the grounds for, in my case, as it is, my lord, the ground, my lord, in 18, if your lordship sees item number 18 at page 78, that is in September 25.
Yes. Page?
This is, my lord, page 78.
Office memorial.
Just if your lordship sees the third line, the suspension order will revoke after obtaining no objection certificate from Board of Wildlife, Ministry of, it should be Ministry of Environment, Forest and Climate Change. So even the, at least in my cases, my lords.
And there is another one. They have also used a very unambiguous term out there. And other statutory body clearing. You see,
But that is in all the cases, mine EC and, but that is not that they are saying that we fall in an area where it is illegal to carry out mining, as is sought to be projected in the affidavits now.
No, whatever it may be, this has been issued by the Department of Environment, Forest, Karbi Anglong, but they duly
No, that is
accepted. they really accept what they have given many reasons. The fault, the reason why they have done it is because of that
Because of
35.
that CSE law.
Everywhere it boils down to 35. They have not assigned that reason.
No, correct.
But if you
I mean, that
see
is why
the
they
other
have, my lord, the
affidavit,
orders will be have to be tested on the grounds assigned.
what do you
That
say
was,
about the recent judgment where it says all others, there other aspects also there if it is there on records?
that is true, but by Mohinder Singh Gill onwards, my lords, the
That has been interpreted as subsequently by the Supreme Court to mean that also. But anyways, let us not go
anyway
into
that
that.
my lord, that
If
that
we
also
can
will
clear
hold.
the hurdle with 35,
My,
then things move.
yes, my
Because
lord.
they
I'm
have
just
to
pointing
normally
out.
report it to the central government.
My
How
lord is
do they
right.
get the power to report it to the state government and direct? Because then they will be taking the authority of over what is the
My lord,
requirement as for the Supreme Court to pass an order or this court to pass an order.
laws, my lord.
Therefore,
That
let us get that
proceedings
clear.
should close, my lord. My lord, the last TD Godavaran order I've just passed on to my learned friend. It may be of interest to your lordship. They are in the process of closing. It is not closed as yet, my lords.
So therefore, it is good. It is in the process of closing. That means once this exercise has been completed, the instant bearers shall be listed before a bench of treasurer for further after obtaining directions from the imam. In the meanwhile, permit new interlocutor to be filed in the instant. However, the insurance such freshly filed alia shall not be numbered or taken on record till further directions of this court. Once the form has been filed, the above mentioned form shall also permit alia. What do they do? In the context of preceding observation is the first step towards the efficiency and judiciary of the pending issue. Okay. The learned amicus then online and accessible questionnaire seeking details of all IS pending in it. Shall elicit entirely in details the details of the applicant so and so so and so so and so.
दिया नहीं इसे दी दी
So what happened on 27?
My lords, after that, no effective orders have been passed, my lords.
Obtaining the directions for the chief justice on the administrative side.
Yeah.
Are pending in each case. The task of identifying, I think, relating to closing.
This, I think, all this will be now. No further IAs will be entertained. It will be in the form
Because
of.
of the pendency of 100 to 450 IAs
My lord.
are still pending.
Because every time, my lords, IAs are filed in this writ, my lords. This was the
Complete action of disposal of the main case and identification, categorization, and transfer of AR could be completed through a single judgment with appropriate directions to all stakeholders. What emerges from the oral submissions made during the course of A is that the instant procedure poses a much larger challenge. We may say for three reasons. Firstly, over 800 IAs are pending in the instant writ petition. Many of them are almost 25 years old. This substantially increases the volume of work required to be undertaken to identify. Secondly, various issues raised in the instant are intriguingly explicit. Some pending IS seeking permission for initiating a proposed night safari sought to be operated in so and so Aravali Hills and so and so. So and so. Finally, several of the issues raised in this procedure would concern the subject matter of sumoto writ petitions that have been recently instituted for similar objects. The scope of the would also have to be taken into. I think this is for streamlining this judgment.
My lord is
Appears to
right.
be for streamlining.
Correct.
Because of the pendency, so many
My
IAs,
lord.
it has become next to
My,
impossible to.
my lord is right.
Absolutely. The way it has gone on, Miller,
देखो, so and so declare. Mr. J. Sutia, the learned senior counsel, assisted by so and so, appears on behalf of the Karbi Anglong Autonomous Council. Ms. A. Gayan appears on behalf of the Union of India, learned CGC. Mr. D. Gogoi appears on behalf of the Forest Department. A. Yusha U. Das, additional senior government advocate, appears on behalf of the state of Assam. The present batch of writ petitions have been filed, challenging the actions on the part of the respondent authorities in not permitting the petitioners to carry out the mining in stone quarries in spite of the fact that the petitioners have valid mining leases and the petitioners have also fulfilled, also have obtained the necessary clearances. From the affidavit so filed by the respondent, from the affidavit so filed by the respondent, the divisional forest officer, Karbi Anglong East Division, it transpires that on the basis of certain directions issued by the Central Empowered Committee in New Delhi, a meeting was held on 27/12/2024, whereby it was discussed and decisions were taken that the divisional forest officer, Karbi Anglong East Division, would issue a ban on all mining activities in Dolmara area, Parkup Pahar area, from south of Bagori to Borjuli waterfall areas with immediate effect. The consequential action, the consequence thereof was the issuance of the communication date, issuance of the order dated 29/1/2025, whereby the petitioner, whereby there was a ban on all mining activities in Dolmara area, Parkup Pahar area, from south of Bagori to Borjuri waterfall. This suspension of the minings was put to challenge by filing a writ petition in WPC number, Mr. Bora, 1003 and 1009. 1003 or 1009 in WPC of 2025, wherein the learned coordinate bench of this court by an order dated 5/5/2025 directed the revocation of the said suspension order and to issue such notifications within a week's time. It is also seen from the records that on 8/5/2025. The order dated 29/1/2025 was revoked. In addition to that, on 14/5/2025, there is also another communication issued by this is being issued by whom? Divisional Forest Officer Yeah. Whereby the communication dated 29/1/2025 was revoked. The records further revealed that based upon an anonymous complaint, the Central Empowered Committee which was constituted in exercise of the powers under Section 3(3) of the Environment Protection Act 1986 by the notification dated 5th of September 2023. Based upon the order dated 12, what is that order? 12/4/2019, passed certain directions. Amongst the various directions, the directions pass certain directions. Where is that in your affidavit here? Order. Page 147 of retaining debt. Mister, where is that document? Which page? 34. Which matter should I take? No, where is that? Here, 5220, I'll find that. Certain directions. Before dealing with the directions which were passed by the chairman of the CEC, it is also relevant to take note of the basis on which the said directions were passed. In the order dated 12/4/2019, the Supreme Court passed directions to the effect that all kinds of mining and related activities along the aforesaid Kaziranga National Park area and in the entire catchment area of rivers/streams and rivulets originating in Karbi Anglong hill ranges and flowing into Kaziranga National Park, including tiger reserves, were restrained. Further to that, there was also a direction passed by the Supreme Court in the said order to the effect that the Director General of Police, Assam, and the concerned Superintendent of Police shall also ensure that no illegal mining takes place in the aforesaid area and no transportation of illegally mined materials takes place from Karbi Anglong Hills. In the above perspective, this court finds it relevant to take note of the directions which were issued in the communication dated 30/5/2025 issued to the Chief Secretary to the Government of Assam The said directions being relevant are reproduced here in under page 238 or 8 to 10, 110 na lage 1 2 3 4 kore likho ha 1 2 3 4 7 lekhe ase. It's good. Having perused those the above quoted directions, finds it relevant to observe that the said directions do not appear to be in the context of the power which has been conferred upon the CEC in the notification dated 5/9/2023. Inasmuch as at clause 2 of the notification, the following powers have been endowed, have been conferred upon the CEC. Clause 2A to 2B. This court also finds it, from a perusal of the above quoted powers conferred, and more particularly in the context of monitoring the implementation of the Supreme Court's order passed in the case of T.N. Godavaran Thirupad versus Union of India and others, the jurisdiction of the CEC appears to be only to place reports of non-compliance before the central government for appropriate action. This court also finds it relevant to take note of clause 3 and clause 4. Of the said notification, which also shows that if there is any suggestion or recommendation of the Central Empowered Committee which is not acceptable to the state government, to the state government, or in case of deferment of the decision of the state government with the recommendation of the Central Empowered Committee, the matter has to be referred to the central government. And in that regard, the decision of the central government would be binding. Under such circumstances, taking into account that the actions which have been taken by the Karbi Anglong Autonomous Council to not to allow the petitioners to run their mining activities is on account of the order dated 30/5/2025 of the communication dated 30/5/2025 issued by the chairman of the CEC to the respondent, to the Chief Secretary Assam. This court would like to be apprised by the central government, by the government of India, as to whether the CEC has the power to issue such directions to the state government in as much as what the CEC can do so, in as much as it prima facie appears from the notification dated so and so, 5 September 2023, that what the CAC can do is only suggestion or make recommendations and not directions. The Mr. R.K. Dev Chaudhary, the learned DYSGI, shall apprise this court on the next date. Mr. J. Zutia, the learned senior counsel as well as the standing counsel of the Karbi Anglong Autonomous Council further submitted that in the meantime, the Karbi Anglong Autonomous Council, in order to make effective compliance to the order dated 12/4/2019, have also made, what did you do? You say no, if you file an affidavit.
Page 220, we have the drainage pattern analysis for water said, including river streams, rivulets falling under Parku Pahar range. That were report on the my lord
Have
catchment area.
also made a report in association with the IIT
Roorkee, madam.
and would like to place the same before this court by filing an additional affidavit. The said additional affidavit be filed within
2 weeks, my lord. 2 weeks.
within 2 weeks. List this matter again on when? 27th, 25th, 25th, not possible. 27th?
1st September, 8th September,
You're there, Mr. Gustami?
1st September.
You're there on 27th?
Your lordship, please. 27?
1st September, lordship.
Okay. 1st September is closed, that is why.
Oh, madam.
Third. Or second.
8th September,
3rd,
3rd, madam.
3rd September. এইখনত পাব দেই এই কাগজখিনি এইটো 5203 আৰু এইখন নটিফিকেশন কোন কৰিছে এইখন ইয়াত তাত 195 আছে আৰু এইখন এফিডেভিট ইন অপজিশনৰ এইখন লেটাৰখন Wait the 35 again, 35 economics. 35 economics. 239 months. 5233. Now, if we can get this thing sorted out, then there is no problem. Anyway, Supreme Court have asked no more filing of IAs, so obviously I can't ask you to go. Okay.
Your lordship is
Deeply obliged, ma'am.
Parted, I suppose.
Okay, Pathak, let's, but it is yet to be, let's, okay, list the matter for further hearing. Okay, okay. Yes,
My lord, we have filed the IA. And last occasion, it was told that
madam,
on 2022.
madam, you have to understand one thing. In an IA, you are challenging an original order.
Yes, my
Is it permissible? No. If you have to challenge it by way of, yeah, I can give you the leave for that if you have
Yes,
not
ma'am.
challenged it.
Yes, ma'am, that much.
Within how much time? 90 days is there, no? Filing under 107?
Yes, my lord, 107, but the limitation is already over, my lord. I'm.
It's okay, no problem. I grant you,
Yeah.
there was a stay passed by this court.
Yes, my lord.
So therefore, from the date of filing of the IA,
Yes, my.
you get the entire period from the date of filing of the IA till file the IA when?
11/5.
11.
12/5/2026.
26.
And when was the impugn order passed?
12/2/2026.
22.
12/2.
Anyways, I give you the limitation of filing within 1 month.
Yes.
Okay. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.C. Kyle, the learned senior counsel, as well as the standing counsel of the GST. Assisted by Mr. K. Jain, appears on behalf of the respondent numbers
1, 2, 3.
1, 2, and 3. 1, 2, and 3. 3. Well, Mr. M. Bhuya appears on behalf of the respondent number 3, 4, 5, 6, and 7. The present petition was filed by the petitioner, challenging what did you challenge?
Page 55, my lord.
Huh?
Page 55, Annex 7.
Challenging the notice
Annex 7, page 55, years 01 notice.
Where is your notice? This is the notice.
One is in
Page
page
48.
48. Annex
Page 48 and 52.
48
And
and
55.
55.
Challenging the notice for intimating. Okay. Challenging the notice issued under section 61 of the Is this the section 74 notice? Is this one? Page 55?
No, Lordship, page 55.
Page 55 is 74.
Page 55 is the
24.
section 74 notice.
Lordship.
Yes.
You can't give a notice like this.
But this is issued by the state government, Lord.
Huh?
It is by the state
State.
GST, Lord. Notice was issued by the state GST, Lord.
It should be the 73.
But did you issue notice in the other matter?
No, Lord. In this so-called notice was issued, but the final order was passed on 11/2.
So-called notice was issued by the state GST.
Lordship, in this case, what happened, the state GST as well as the state GST initiated the proceeding. But it
State
was,
GST had issued section 74 notice.
Lordship,
Did the central GST issue the notice or not?
Lordship. This case correct.
They have issued on 25.
25.
I've challenged the show cause notice dated 1/4/2022 issued by the respondent number
Assistant Commissioner. Yes. 3.
7.
7.
7.
Respondent number 7. I challenge the notice under section 74 of the Assam Goods and Service Tax Act 2017 issued by the respondent number 7. Whereby the petitioner was asked to submit their reply by 30/4/2022. Full stop. The records reveal that the learned coordinate bench of this court by an order dated 29/6/2022 state directed the respondents in the state GST not to take any coercive action on the petitioner in terms of the impugned notice dated 1/4/2022 issued under section 74 of the Assam Goods and Service Tax Act 2017. The interim order thereupon have been extended from time to time. In the meantime, it is also apparent from the interlocutory application filed by the petitioner being ISCs 1709/2026 that a show cause notice was issued to the petitioner on 23/7/2025. By the respondent number 3. Under section 74 of the Central Goods and Service Tax Act 2017. Petitioner participated in the said proceedings as would appear from the contents of the order dated 12/2/2020, order in original dated 12/2/2026, more particularly at paragraph 1.10. The respondent number 3 passed the order in original dated 12/2/2026, whereby an amount of rupees 1,36,96,200 was demanded as the short paid tax along with interest in terms with section 50 of the Central Goods and Service Tax Act 2017 and the Assam State Goods and Service Tax Act 2017. and further directed, further demanded penalty equivalent to the amount as mentioned in penalty equivalent to rupees 1,00,96,96,200 under section 74(9) of the CGST Act 2017 and ASG ST Act 2017. This order in original dated 12/2/2026, instead of being challenged in an appeal as permissible under section 107 of the CGST Act 2017, was collaterally challenged in the writ proceedings. The learned coordinate bench of this court by an order dated 22/6/2016, while issuing notice directed that no coercive action should be taken against the petitioner in terms with the order in original dated 12/2/2026. It is in the backdrop of the above, the present writ proceedings are taken up for disposal. This court have duly taken note of the contents of the interlocutor. This no. It is relevant to take note of that the proceedings in the writ petition the challenge in the writ petition has no correlation with the challenge in the interlocutory application. There was also no stay or any interim directions against the central against the proper officer under the CGST Act 2017 to initiate any proceedings under section 74 of the Act of 2017. Under such circumstances, the challenge to made by way of an interlocutory application to the order in original dated 12/2/2026 was completely misconceived. This court have also taken note of the order in original dated 12/2/2026 and does not, and there appears to be no jurisdictional error committed by the proper officer. For this court to exercise the extraordinary jurisdiction under Article 2 to 6 of the Constitution. Accordingly, it is therefore the opinion of this court that the writ petition had already become infructuous in view of the proceedings which have been initiated by the authorities under the Central Goods and Service Tax Act 2017 and the order passed and the order in original passed on 12/2/2026 by the respondent number 3. Insofar as the order in original dated 12/2/2023 passed by the respondent number 3, there is no jurisdictional error. Under such circumstances, in that view of the matter, the question of exercising the jurisdiction under Article 2 to 6 of the Constitution does not arise. Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that on a mistaken advice, the petitioner had approached this court by filing an interlocutory application. And further, this court had also passed an order by issuing notice and passed an order, thereby protecting the petitioners with certain interim directions. It is under such circumstances the learned counsel therefore submitted that if the instant writ petition is dismissed, the petitioner would have no other avenue available, taking into account that the period of limitation as prescribed under Section 107 of the Central Goods and Service Tax Act 2017 had already in the meantime expired from the date of the order in original. This court had given an anxious consideration to the above submission and is of the opinion that as on a mistaken advice, the petitioner had approached this court and the petitioner had been diligently and bona fidely pursuing the present proceedings. The petitioner should be granted and this court is not inclined to entertain the instant writ petition for the reasons aforementioned. The petitioner should be granted an opportunity to avail the appellate remedy as provided under Section 107 of the CGST Act 2017. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. Number 1, the writ petition. The challenge to the notice dated 1/4/2022 issued by the respondent number 7 had become infructuous in view of the passing of the order dated 12/2/2026, order in original dated 12 by the respondent number 3. Accordingly, the reliefs which have been sought for in the writ petition cannot be granted. Number 2, the challenge to the order in original issued by the respondent number 3, dated so and so, by way of an interlocutory application is totally misconceived. In addition to that, this court also do not find any jurisdictional error committed by the proper officer by the respondent number 3 in passing the order in original dated 12/2/2026. Number 3. This court grants the liberty to the petitioner to avail remedies before the statutory authorities under Section 107 of the CGST Act 2017. Further to that, this court observes, for the reasons already stated herein above, that if the petitioner files an appeal before the appellate authority under Section 107 of the CGST Act 2017, within a period of 1 month from 30 days from today, the said appeal be considered by the appellate authority without insisting on the question of limitation. The interim order passed earlier stands vacated. Mr. Sharma, R.P. Sharma, you see, in your case, I was about to deliver the judgment. Although I was taking it was a simple matter for me, so there was no problem to deliver the judgment. Well, making the judgment, then I found, oh, this particular person, Iftikhar Azad, is not made a party. There was no problem otherwise. But when I saw the assessment sheet, he is now the civil registrar of this Bilasipara, from where you have been reverted to as the UDA. So don't you think that he needs to be made a party? Because if I don't make him a party, tomorrow he will come up and say that, look here, I was not made a, now I am now put down. I do one thing, you don't need to file an application. I make them a party, you take steps.
Okay. Okay.
You are for?
I am for respondent number 2, 3, 4, and 5.
What is that?
Respondent number.
High Court.
I got it.
It is item number 2. It is to be spoken to this. Heard Mr. R.P. Sharma, the learned senior counsel, assisted by so-and-so, appearing on behalf of the petitioner.
Yes, Dinya.
Miss,
D.
you are
Bora?
not a standing counsel.
No, I am
None
on
of
behalf
you.
of Z Voice.
Oh,
Z Voice, sir. Z Voice, sir.
you cannot. This is not permissible. No? This court have wide an order dated 11/6/2026 reserved the judgment after concluding the hearing. At the time of preparation of the judgment, it could be noticed from Annexure 33 that one Iftikhar Azad was appointed as the civil solicitor in the office of the Civil Judge Junior Division Bilasipara after demoting the petitioner from the said post to the post of UDA. It could also be noticed from the writ petition that the said Iftikhar Azad is not a party to the present proceedings. And in absence of him, any directions of past in the writ petition on the issue pertaining to the legality or validity of the actions on the part of the respondent authorities to demote the petitioner from the post of civil solicitor to the UDA would not be in the interest of justice. This court also is of the opinion that that Iftikhar Azad, Sri Iftikhar Azad, is a necessary party to the present proceedings. Accordingly, this court impledes Iftikhar Azad, Civil Solicitor, Office of the Civil Judge, Junior Division, Bilasipara, as the respondent number 7 to the present proceedings. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court. And the registry, on the basis thereof, shall make necessary correction of the records of the cause title and update the same in the CIS. The said memo of parties be filed, submitted before the registry within 3 days. First, next. Okay. Issue notice upon the newly impleaded respondent number 7. Ms. So-and-so, assisting Mr. G. Boisha, the learned senior counsel, as well as the standing counsel of the Gauhati High Court. Issue notice upon the so-and-so, returnable by 10th of September 2026. The counsel for the petitioner is directed to serve a copy of the writ petition to Miss So-and-so, the learned counsel assisting Mr. G. Boisha, the learned senior counsel, as well as the standing counsel of the Gauhati High Court. Ms. Deborah shall take steps for effecting service upon the respondent number, newly impleaded respondent number 7, through the respondent number 5, with the report in that regard. The respondent number 7 shall be at liberty to bring on record its stand by filing the affidavit on or before 7th of September. That is the only question otherwise, if I pass a direction, again the same problem will. Huh? This one CV will. I asked you to do something, find out something.
That order from the secretary, from the government.
I've asked you to get that copy of that letter, na? So here the reason seems to be different. Only on the bid validity,
Bid validity expiry.
not on the question of embankment change.
Although we have written to the government, but part has been left out, Lordship. Although I have got the office file also, Lordship. Records are with me, Lordship.
No, if the thing has changed, Mr. Hawk, I can't help you.
Here, my lord, one thing is
I can direct them to again go ahead with the tender process in respect to a work which no longer exists now.
Yes, Lordship.
Things have changed. I can't help you
my
with
lord,
that.
if the, my lord, that-
Understood. That was right or wrong, but you can't help it. This is how the legal process is. As of now, if I say to them, then look here, no, you have to do this.
my lord,
You have to still give them in respect to a thing which is not adequate now to do it, then it would not be proper on the part of this court. I understand, Mr. Hawk.
my lord,
On the administrative side, I am with you, but not on the judicial side.
my lord, think that, my lord, that work is still persist, my lord. That work, my lord, which was advertised, my lord, that work is still there, my lord. Now they want to add 100 to 120, 120 meters, my lord, of, my lord, erosion, my lord. My lord, there is always a provision, my lord, for variation. Variation clause is there, my lord. They can, my lord, amend the BOQ, my lord.
Mr. Hawk, very well. All understood. The question is, why should I say it to them? Can I direct them that this additional work, you make it an additional package? Can I direct them?
My lord, they are saying that, my lord,
We
that,
do one thing. We academically go ahead, we vacate the interim order. And in the meantime, you do ahead and then we will decide what happens.
No, we will issue a fresh tender, Lordship. We will issue a fresh tender, Lordship.
Don't give it to just
No.
without a tender.
No. It will be online tender, Lordship.
We do one thing, keep the matter pending. Let them go ahead with the fresh. And then we will see you participate without prejudice.
Yes.
That is the only way out. Because otherwise, what will happen is, if the scope is enlarged,
Madam.
you see, Mr. Hawk, I will always like to help you out.
yes, my lord.
But the
I
fact
appreciate it.
is, you see, my hands are tied. And in your case, if I pass this order, out of my fondness for Mr. S. Hawk,
I mean, really,
no, but the remaining is this order will affect, he's going, all other councils will show me. I tell you, this is
Really?
a very difficult thing. I'm very particular on this.
I'm very much
You
pleased.
see, otherwise it becomes a very difficult. You have
Yes,
to
my
wait.
lord. Yes, sir. I appreciate.
Because in this case, if I say that no, whatever may be, extra work, whatever you include it and give it to him, and the less later on you took that. That means
Well, it
this
is-
court means the judgment, the Jagdish Prasad judgment, the judges who have written it, as well as the what you call the other people who read that judgment later on, we just laugh. And sometimes that order, if it is again placed, they already passed a similar order. Why not my case also? And it becomes very difficult.
My lord, in this present scenario, what they have done, my lord? They had waited, my lord. They had waited for 5 months, my lord. In the reverse side, my lord.
All
definitely they will-
understood.
Yes, yes, I,
All
yes.
understood. But the fact, therefore, I'm keeping it pending.
Yes, my lord.
Your
So that
Lordship is
if you
very much
don't
correct.
get it, then we'll see. We will say that any fresh tender issued shall be subject to the outcome.
Yes, my lord.
And you don't have any problem.
Yes, yes.
And your Lordship is very much correct that allowing him to participate in the tender. He can participate in the fresh
Allowing
tender.
him to
Let him participate.
One is a case of not issuing the tender.
Yes, my lord.
No,
And
not
that-
issuing the work order. Not issuing the work order.
But that has become infructuous.
Yes.
My lord,
Work order.
Not issuing the work order has become infructuous.
Yes.
Because of the cancellation of the tender.
Cancellation of.
When I am allowing you to participate,
my lord.
allowing you to
Yes, yes, ma'am.
participate, can the court say that then also the issuance of the work order will be there?
No. That will definitely not work.
Because at the end of the day, Mr. Hawk, if you have suffered anything, it is for you to go and ask for compensation. That is the main thing. You see, tender works in that manner.
My lord, what happened in this case?
Moreover,
Just
I understand.
I'm pleasing, my
You
lord.
need not say.
Yeah, okay.
I have understood
I know, I
you
know.
were number one.
Yes.
You expected it. One fine morning you see the beloved persons of the respondent authority, he is cleaning something, and therefore, out of apprehension, you come before this court filing this writ petition.
My lord.
And I said that, okay, do whatever may be, but don't issue any except to the petitioner. That's the order.
Right.
Thereupon, you come up with the other case, then look here, they have cancelled it.
Yes, my lord.
They have cancelled it, and now if they have cancelled it, and they say that they cannot cancel it in this manner,
My lord.
because I was there just to do it. Now they give us a reason to the effect that there are three reasons. The first reason is the area had changed.
Yes.
Second, the bid validity, and the third,
Lordship,
That is the
expiry.
only two ex- only two
Expiry.
aspects. Bid
Bid
validity
validity
expiry.
expired.
and the
And
other
the
is the
site
scope
change.
has changed.
Site has been changed.
Why should I keep the matter pending?
Lordship may dispose of Lordship. If he is being aggrieved, he can file a fresh one, Lordship.
My lord, just I'm submitting, my lord. There are two identical words, my lord. They-
I
how
understand.
Article
One
14
has been
violated-
given. One has been given to you, na.
Yes, my lord.
You're working.
That is 2 crore only, my lord.
Yes, one
That
work
is
order
two
is
crore,
there.
my lord, that's given. That's most probably already done. 8 crore come, my lord. 8 work, my lord. They
Now it
should-
will become 10, na.
Lordship.
Huh?
Yes.
See, you
Work
get
will,
more money now.
work will increase, Lordship.
Huh?
Work order will increase.
No, they are saying
Value will
within
be-
the administrative approved value. They are saying that within the administrative approved value.
Okay.
Lordship.
Let dispose it off.
Lordship.
Give you the liberty. If you have taken the issue.
But just
One has become infructuous.
yes,
One
because
case.
that in cases they have made, my lord, in blatant violation of this court order, my lord. While the court earlier in the earlier case, my lord, had issued order, my lord, fixing a date, my lord, the returnable date. In that during the course of the date, my lord, they had cancelled this, my lord.
Did I ask him not to cancel?
No.
No, my lord.
Then Mr. Hawk, you should now be doing some matters in bench one.
My
Then
lord,
you will understand.
yes. I will
Ah,
appreciate that, my lord.
yeah.
Sometimes they appear, my lord, in this matter.
Heard Mr. I'll close it.
Lordship.
Heard Mr. S. Hawk, the learned counsel, appearing on behalf of the petitioner, Mr. R.M. Das, the learned counsel, who appears on behalf of the Water Resource Department. Both the petitions are taken up together for disposal by this common order. Common order. A notice inviting tender was issued on 26/8/2025 for various works, including the work of, which one?
Well, let's paste.
Serial number?
Page number 28, my lord. Page 20,
Including the work of, which one?
28, my lord. Construction of
Construction
embankment.
of embankment on R/B of river Buradia from Krishna Guru Seva Ashram to Purni and Purni to Triveni Ghat, including 2 shutter sluice at Purni. The petitioner being interested participated in the said tender process. The petitioner's bid, along with 2 others, were found to be technically competent. Thereupon, the financial bid was opened.
Page 85, my lord. There is a quotation of this order, my lord. Page 80. Second one, my lord.
On 2/2/2026.
23/2, my lord.
Huh?
The finance bid for the same was opened on 23/2.
On 23/2/2026,
Yes, my lord.
wherein the petitioner was the lowest bidder.
Yes.
It is the further case of the petitioner that in respect to another work of the same tender,
That's number 27.
the petitioner, being the lowest bidder, was issued the letter of acceptance on 15/3/2026. But there was no letter of acceptance issued to the petitioner in respect to the present contract in question. It is the further case of the petitioner that in the meantime, steps were being taken by the respondents to hand over the said work for which the petitioner was the L1 bidder to a third party. And under such circumstances, the petitioner therefore approached this court by filing the writ petition, which was registered and numbered as WPC number 2695/2026. This court, by an order dated 22/5/2026, issued notice and further directed the respondent authorities not to allot the work in question to any other bidder. So it was, however, clarified that in the circumstance that the said order shall not preclude the respondent authorities to grant the contract to the petitioner if otherwise satisfied with the petitioner's credentials. It is the further case of the petitioner while the said interim order continued. The respondent authorities issued a cancellation notice on 27/5/2026. Stipulating the ground that the period cancellation notice dated 27/5/2026, thereby cancelling the said tender process in respect to the contract in question owing to the expiry of the bid validity period. The petitioner aggrieved, filed the second writ petition before this court, which was registered and numbered as WPC number 2936/2026. This court, by an order dated 8/6/2026, while issuing notice, passed an interim direction upon the respondent authorities not to take any further steps for calling for fresh tender in respect to the said work, which is the subject matter of the impugned cancellation notice dated 27/5/2026 till the next date. The respondents, number 2, had filed an affidavit in opposition, wherein it was mentioned that after the cancellation notice was issued on 27/5/2026, the earnest money which was paid by the petitioner was returned. It was also mentioned at paragraph number 13 that the executive engineer, Nalbari Water Resource Department, by their letter, had reported severe bank erosion at Purnipam along the river banks of River Burdia. The erosion had already affected a stretch of approximately 120 meters and is posing an imminent threat to the nearby habitation, public infrastructure, and adjoining areas. It was also mentioned in the said letter by the executive engineer that the site conditions have undergone significant changes since preparation of the original estimate, and has requested incorporation of an urgent anti-erosion protection measures to address the emergent situation and persistent public demand. It is under such circumstances, considering the expiry of the bid validity. I told you not 3 reasons. Yes, I remember more.
I'm sorry. I'm sorry, Lordship.
Non-finalization of the tender process and substantial change in the site conditions requiring modification of the project scope in public interest. It was considered administratively and technically necessary to cancel the existing tender process and take up a revised proposal incorporating the required anti-erosion protection measures. The question arises before this court in the present proceedings that can this court, in exercise of the powers under Article 2 to 6 of the Constitution, interfere with the cancellation notice dated 27/5/2026. This court also takes note of that though in the order dated 27/5/2026, the reason has been assigned to be that the expiry of the bid validity period. But on a perusal of the records, and more particularly the communication which have been issued by the executive engineer, which shows that there is an enlargement of the scope of the work, it is the opinion of this court that the powers of judicial review cannot be extended to such a limit to interfere with the cancellation notice. Taking into account that it is the tendering authority who has the expertise to decide as to whether in the present contract, which is the subject matter of the writ petition, or by way of a new contract, the scope of the work is to be carried out. Accordingly, this court does not find any ground for interference under Article 2 to 6 of the Constitution, for which the writ petition stands closed. It is observed that both the writ petition stands closed. It is before parting with the record, this court, however, observes that the closure of the instant writ petition shall not preclude the petitioner to participate in the fresh tender. And if there is any grievance in respect to the fresh tender, the petitioner would always be at liberty to approach this court, if so permissible under law.
Right.
Yes, Mr. D. Chakravarti and
Interim orders? Interim
orders stands speaking. What is the limited extent on which I have to interfere now?
My lord, the last order perhaps was the stage where we reached up to, where, my lord, the two queries which fell from your lordship's mouth was whether the municipal authority having the right of levying tax also has the right of enhancing tax within the meaning of section 68. That was one. And other was whether betterment fees can be increased without increasing the ARV, that is the annual rental value. Now, on that aspect, your lordship, my lord.
Yes. Mr. This is a very important question.
Yes, my lord,
Can you increase? It's a very fundamental question on that.
Yes.
Because I could see from section 79, all are related to the annual rental value.
yes,
So therefore, your tax or whatever your holding tax or whatever is done, or if you see the water tax is 2%, holding tax 3%. All these things are having a correlation with the code. Even your case is also tap charge.
tap charges.
You are having a tap charge of a particular amount, which was earlier 125, now it has become 350 or 300, whatever it may
Exactly.
be. So therefore, the question arises is, can you increase? What is the parameter of increasing? Means there has to be some power somewhere
Yes.
for increasing.
My answer to that question would be, my lord, if your lordship take up the chapter 5, there is a municipal taxation as envisaged under section 68 taxes.
Yes.
Now your lordship will find all these are relating to tax, but somewhere your lordship will find license fee, then fee for the registration. Now, so our case is, it's a betterment fee at 68K. A betterment fee on holdings in any area of which value has increased due to improvement schemes.
You are
calculated at
coming under
board
68
68K, my lord.
K, a betterment fee on holdings
Yes.
in area. So therefore, it has a
Yes.
correlation with the holdings.
Right.
So how do you increase it?
Right. Your lordships, the next query was that whether there is a provision for enhancement. Now, I will take your lordships to 79F because these are all taxes. 79F.
Yes.
Determination of taxes. The rate of taxes determined in accordance with the provision of this Act shall be published by the respective municipal board town committee by issuing a public notice within a period of 3 months from the date of coming into force of the Assam Municipal Amendment Act 2012. This determination shall remain valid for a period of 5 years. At the expiration of 5 years, at the expiration of every 5 years, new determination of rate of taxes shall take place and shall be published in the same manner as stipulated in this section. So these are talking about all taxes. Now, if
But your case is not tax.
my lord, it is under tax, my lord.
The moment we come to tax, you fall into another problem out here.
Now, your
For
lordship,
publication, because you now say it is
publication,
not a
of
tax.
course. Right. Publication, my lord, we required to publish it, but they used to hang it in their notice board. That's
So
a very
therefore, the moment you are putting into the tax, you then have to follow 79B. 79?
79, possibly 79F, my lord, regarding publication.
79.
And 79B talks about methods of calculation of capital.
Where is given it is?
Your lordship is
79B
talking
or
about
something, no?
79F speaks of publication, and published it's defined under section
There is a
79.2.
definition of how the publish.
79.2.
79.2.
Yes.
Publish means are published in one vernacular and one English daily.
Yes.
So therefore, you fall into that trap.
That's okay, my lord, because they are, in my personal opinion, my lord, they're required to publish it so that it goes to the every citizen.
We do one thing. I was thinking after hearing, although that day you were not present, or I thought you were not present most probably. You see, I was thinking aloud because you need to also take care of how it is, because these publications should have been made as per law.
Yes.
The power, if it is to be done, he also needs to be published.
Yes.
So if the fee or tax, whatever may be, it needs to be published if there is an increase.
Yes.
Being 79.
Very correct.
Now, I was thinking, you see, the Silchar Municipal Board is running with that amount, whatever may be. Question of refund does not arise. I can dispose of the petition with the direction that this will remain as it is, but subsequently, asking you to issue a proper notice.
Yes.
give an opportunity of hearing to all persons. And thereupon consider as to whether to maintain the rate at 300 or less, not more.
Right.
Because you cannot change for 5 years. Which rate is necessary, and thereupon take it up. I think that seems to be better.
I think, my lord.
You are also protected. Because you see, at the end of the day, the question is one needs to follow the law. But if you don't follow the law, there's no way out. Means we need to interfere.
Yes.
But running of a organization is also very important. That particular CEO or whatever the executive officer must have thought that they can do whatever they feel like. They must have done it. So therefore, I think this appears to be more reasonable order.
Absolutely. Gleefully, my lord, I shall accept this.
Because that is the way out. Because you have to also consider, if I was the lawyer out here, I would have obviously said no. But for a judge, one need to think about what will be the impact, because the closing down in view of the money being not there and the closing down of the water tax on account of a few would not be in the interest of administration.
Exactly, my lord.
I think that appears to be a very fair.
I think that's the best way to solve it out.
That day I thought about that. After
In fact, your lordship said that your lordship is thinking to pass the order that manner.
Huh?
Your lordship, in fact, said that your lordship is proposed to pass the order that manner.
But that seems to be the most
Yes.
logical culmination of this dispute.
Man.
Thereby, yes, they have a right of say. Obviously, how much expertise should be 300 or 150, whatever may be, it cannot be at the whims of the executive officer. It has to be on the basis of a consultation, because the municipality is also a local self-government. Therefore, you have this 243 these being brought in.
Right.
Like the rural panchayat, you have the municipality. So that is also a local self-government. So he has to take a decision on the basis of that. And this was taken at the time when I think the board was under suspension. Or is it still?
No.
Still,
Now
it is now about to have his election.
Now-
That other matter, my lord, the direction has been passed.
Direction already been passed.
Within 2 months, election has to be held. So that way, that matter is resolved. Now this one remains.
I don't have a CAB. I can CAB because if I do a CAB, matter becomes very long, lengthy judgment. So I don't think so long. I don't do CAB. That is the reason why. But then once it goes inside, it becomes very time.
Yes.
Time consuming. Means you don't go into. Don't feel okay now. The court it is better finish it off.
And memory is fresh also.
Memory is fresh, but it's too late today. I think this is the reasonable one. We passed the judgment on 20 तारीख है at 10 o'clock, 10:30, first second.
20th, 20.
For
I passed the judgment in your presence.
Much obliged.
This is the order which I think appears to be most reasonable.
It's very reasonable. Law.
Deeply obliged, my lord. This matter, if your lordship kindly peruses the last order passed on 21/5/2026. Here, both union under the Ministry of Urban Affairs and the state under the Department of Social Welfare were directed to
That is
place-
why you were saying to me that you missed the bus for 2 matters, so you don't want to miss the bus for the third by retrying it. I never thought. I thought there was somebody else out there. Yes, tell me, what is that? In the
What is the
meanwhile,
pursuant-
central government and ER more particularly aforesaid shall consult with each other in the aforesaid aspect. Oh, yes, I understand.
The
What happened?
pursuant to that order, Lordship, last order,
Anything happened?
the government has sought some report from the district commissioner as well as from the director level, Lordship.
It
That,
requires to be repaired.
yes, yes. Yeah.
I mean, I think this
So
needs to
that
be done.
report is awaited, Lordship. After receiving the report, Lordship, accordingly, they will proceed with the matter, Lordship.
I think from now onwards, cost I shall pay to the Central Destitute Home. Whenever I impose cost, that is the only way it will happen. If I start taking from the litigants. If the governments are not doing it, then there's no way out. 99 people are residing there. Something thing, see the basic human condition.
They have intimated
They had asked for something else, Pradhan Mantri and all. Forget about that. But this is basic human rights.
Yes.
Yes, my lord.
When are you doing it? Do something. Where will they go?
The
We say a lot of things on basic human rights and all. These are people who are the senior citizens. Then it's a very bad thing. When can we get a report? Yeah, you cannot just put it. This is the matter needs to be urgently worked out because we are concerned with senior citizens. It's a case where these people have been left out by the family. So therefore, it is the compassion of the state and the center has to be jointly. Matter is simple. Okay, get along. Make it very clear. Come up with a better thing, not like this. Are not capable. The state is the state respondents are not responding to you.
No, Lordship, we have already talked with them. So this
No,
letter has been.
Tell the court, tell these officials.
Lordship.
Look here, this is a case where, therefore, I made it very clear. The petitioners herein, who are 99 in numbers, admittedly belong to the marginalized caste of the society, residing as inmates in the Central Destitute Home. The said destitute home was earlier established on a plot of land which is 57. However, on account of the parts of land being allotted to various institutes and organization by the government of Assam, at present the destitute home is situated over so and so. Herein are there the pitiable state of affairs of the conditions of the destitute home, as there has been no repairs being carried out. It is under such circumstances that the petitioner have joined together and filed the instance so that at least the benefits provided in the Pradhan Mantri Yojana be provided so the destitute home could be renovated, which touches upon the right to life of the petitioners to live with basic dignity. This court implores upon so-and-so and the state government, more particularly housing and so-and-so, to place a proposal before this court as to how the living conditions of so-and-so can be improved. I fixed it after 3 months. It cannot be like this. It's not happening. We need to take some more drastic actions.
Proposal should be moved from the state, but how many, it is different from the scheme, it is out of the scheme. But the directorate, they have informed me that it is not applicable under this scheme.
I'm not on, therefore, I'm not on Pradhan Mantri Yojana. I am saying that let the state and the center work it out and do something for these people. That's a simple question. Plus, for example, yesterday, that day, a Supreme Court said that the central government and the state government and the union territory government shall take care of that in every courts. There is a proper toilet. Okay? The question, therefore, is whoever is responsible. We can't allow these 99 people to rot out there in unpitiable state of affairs. You have lots of money. How much you do it a year? We bring the PWD and ask them to give an estimate. Yes, Mr. B. Gogoi. ask your executive engineer to make an estimate as to how much reasonable, not the PWD types, how much reasonable would be the expenses, so that we can pass appropriate directions upon the state and the center to make payment, do this. Because here we are having a central destitute home. It is not belonging to the petitioners. It belongs to the state. There's no quarrel with that. On account of these being not properly done, they have therefore taken it up. They had to file and say that at least give us this Pradhan Mantri Yojana for the purpose of repairing. But that can't be there. So here, these are people with marginalized classes. So we do one thing, we make the PWD a party, ask the executive engineer which division.
Sir, this will be building, I suppose.
Huh?
Building.
It will be building.
PWD.
PWD building which, where?
Silchar division.
Executive engineer, Silchar division to inspect and provide an estimate, reasonable. But when I said estimate, you will confirm as reasonable. This court passed an order on 21/5/2026, imploring upon the central government and the state government to place a proposal before this court as to how the living conditions of the inmates of the central destitute home Meherpur, Silchar can be improved by carrying out renovations and repairs. Almost 3 months have passed by, but there is nothing which have been placed before this court. This court is concerned that this court in the order dated 21/5/2026 has clearly observed the right to life includes the right to live with basic dignity, which is a fundamental right under Article 21 of the Constitution. The state government as well as the central government are bound to take care of the people who are even not in a position to provide, not in a position to take care of the people. The central government, the state government, full stop. The petitioners herein are residing in the center, in the central destitute home, which admittedly belongs to the state government. It is the responsibility of the state government to see to it that the living conditions are that the petitioners are provided basic living conditions. Which presently is not there on account of the shelter is in a pitiable state of affairs. This court directs, though the PWD department is not a party to the proceedings, but for an effective resolution of the present dispute, this court impledes the chief engineer, PWD building, as well as the executive engineer, PWD, which division?
Silchar division.
Silchar division, as respondent number
10 and 11.
10 and 11 to the instant petition. Mr. B. Gogoi, the learned additional advocate general, Mr. So-and-so shall file a fresh memo of parties. Mr. B. Gogoi, issue notice upon the newly impleted respondent number 10 and 11. Mr. B. Gogoi, the learned additional advocate general, who is also the standing counsel of the PWD, accepts notice on behalf of the said respondent number 10 and 11. The respondent number 11 is directed to provide an estimate of the amount which will be required for the purpose of carrying out the renovation and repairs of the central destitute home Meherpur, Silchar, before this court on the next date. List this matter on 15th of September 2026.
Highly obliged, my lord.
Yes, Mr. Dev, what is your case? You don't have a case.
Lordship, in this case, Lordship, I pray for 10 days more time because on the last occasion, Lordship has asked to file as an affidavit, but the instruction we received yesterday only, Lordship.
Updated status regarding the stand of the in respect to the forward petition.
Lordship,
That I asked you on 23/6.
Lordship, that's why, Lordship, we have received yesterday only, Lordship.
Okay.
That
Okay, we don't give you much time. These are 2023 match, 13 match. What is your updated? What
They-
case you have?
On Lordship, on 10th July, 4th August, we have sent him a information of offer of the appointment, but they didn't turn up, Lordship. They didn't turn up.
Anyways, you file your affidavit that Lordship. Okay, put it on record. So the affidavit which was directed to be filed in terms with the order dated 23/6/2026 have not yet been filed. So considering the above, list this matter, Mr. S.S. Roy appearing on behalf of the central government submits the 7 days time.
Lordship, 10
Oh.
days, 10 days.
10 days time is required. This court takes note of that these present petitions are more than a decade old, and as such directs the respondents to bring on record the stand by filing the affidavit as directed by the order dated 23/6/2026 on or before 8th of September 2026. List the matter on 10th of September 2026, showing it as parted. Yes, Mr. R.K. Bhatt. What is your case? Ah, yes. What happened?
I've got a written instruction. My lord, that particulars were, my lord, provided by the GAD department. Pursuant to that, my lord, the amount was deposited.
So you did not have the bank account details.
We did not have, but my lord, the GAD department, they provided us, and accordingly it was deposited in that particular account.
So the GAD department made the mistake.
Probably, my lord, they have not admitted so. So that's why I say, my lord, let my lord, both the department place it before this honorable court, my lord, what went wrong and why it went to the account of some other
But
person.
how are you, he's concerned with
Otherwise,
his
my lord,
money.
yes, that's why I'm saying, my lord.
So
Otherwise also they
directly
will have to pay,
the amount.
and it can be recovered, my lord, as per.
You recover it. However you recovered, how you recovered, that's
Yes,
your
my
recover. But because that person must have also been your contractor. Otherwise, you don't give it.
Lordship, maybe, my lord, some other.
Unless
party-
somebody has,
Lordship.
you recover, I'm not concerned, but you have to pay how much? 2 weeks?
Will give me some time, my lord, at least 3 weeks, or 4 weeks, my lord, at least outer limit, my lord, 4 weeks.
In 4 weeks, you get the payment. Oh, I'll pass the order.
Ma'am.
Disposed.
So I
God bless you.
ought not to have submitted, my bad, my lord, two matters were dismissed for default, my lord.
Huh?
28 and 29 were dismissed for default.
Ah,
File application, my lord.
why?
Readmission, my lord, the appeals, my names
why
were not
didn't you appeal?
reflected. Names were not reflected, my lord.
But these are all matters.
Yes, my lord.
Do you have a case?
Yes, my lord, I do have a case. my lord.
No case. Miss for default. You impose a cost on the council. You are an insurance company. 2010, do you get a stay?
Yes, sir.
There's a stay also.
Yes. sir. The owner driver himself, my lord.
No, these MIC cases were never there out there.
Yeah, my lord, in fact, 2, 3 courts it were distributed, so I was just stuck up and all my juniors are having some medical exigencies because of that.
They were?
Some medical exigencies on 2, 3 juniors of mine, my lord. And when I went back to the table, the counsel from that chamber only informed me that your matters are dismissed. Then only I came to know that matters were dismissed. My lord. Anyway, my lord, I'll file a readmission application. My lord.
No. Thursday fix query paper. We'll have it on Thursday.
Obliged.
But then on Thursday you should be there.
Yes, my lord, I'll be there.
And if you are not there, then we impose a cost
My lord,
upon the council
I'll be there.
of 10,000 is less for him, 1 lakh.
Obliged. my lord.